Well, good morning, everyone. I declare open this hearing of the Senate Foreign Affairs, Defence and Trade Legislation Committee's inquiry into the Defence Amendment Defence Honours and Awards Appeals Tribunal Bill of 2025. I want to begin by acknowledging the traditional custodians of land on which we meet and pay respects to elders past and present. The committee is being conducted today via video conference, and I'd like to welcome all my colleagues that are present today, including Senator Whitaker, Senator Shoebridge, Senator Collins, Senator Lambie, Senator Cadell, and I'm sure, as I understand, also Senator Pocock later today. These are public proceedings being video streamed via the Parliament's website, and a Hansard transcript will also be made available. I remind all witnesses that in giving evidence to the committee, they are protected by parliamentary privilege. It is unlawful for anyone to threaten or disadvantage a witness on account of evidence given to a committee, and such action may be treated by the Senate as a contempt. It is also contempt to give false or misleading evidence. Witnesses also have a right to request to be heard in camera if they request. The Senate has resolved that an officer of the Department of the Commonwealth or of a state shall not be asked to give opinions on matters of policy and shall be given reasonable opportunity to refer questions asked of the officer or to a superior officer or to a minister. This resolution does not preclude questions asking for explanations of policies or factual questions about when and how policies were adopted. If a witness objects to answering a question, they should state the ground upon which the objection is made, and the committee will determine whether it will insist on an answer, having regard to the ground which it is so claimed. If the committee determines to insist on an answer, a witness may request that the answer be given in camera. Commonwealth officers appearing today are also reminded of the Senate order specifying the process by which a claim of public interest immunity should be raised, and a copy of the order is available from the Secretariat. I remind senators of their obligations under the Behaviour Code for Australian parliamentarians to treat witnesses with dignity, courtesy, fairness and respect. And I remind committee members and all witnesses who are appearing via video conference just to mute your microphone when you're not speaking. Now, before we just kick off, I just also wanted to say on behalf of the committee, as many would be aware, our thoughts are with the three ADF personnel that involved in the single vehicle rollover near Townsville. Been reported over the course of last night and this morning. I want to extend our thoughts and prayers to each of their members and their families and colleagues, particularly those in the three RAR and all others that have been affected by this incident. The committee also wishes to acknowledge the response of the emergency services teams who attended the scene, and I understand that further information will become available in due course, but our thoughts and prayers are with everyone right now. I'll start today and welcome Mr. Stephen Skill, Chair of the Defence Honours and Awards Appeals Tribunal. Hopefully I got your last name there right, Stephen, but welcome, good morning. I understand that information on parliamentary privilege and the protection of witnesses giving evidence to committees has been provided to you. Could I ask for the Hansard record? Could you please state your full name and the capacity in which you appear today?
Certainly, Senator. Stephen Skill, Chair of the Defence Honours and Awards Appeals Tribunal.
Thank you very much. Now, did you have an opening statement you have for the committee, or have you already provided one?
I've provided a copy this morning, and I'm sorry it didn't get to you earlier, but I'll be as short as I can.
Thank you.
The committee has 63 submissions before it in relation to this bill. It's a remarkable fact that 62 of those submissions oppose the bill. Only one submission supports the bill, and that, of course, is the submission from the Department of Defence. So the question is, has Defence got it right and everybody else got it wrong? The Defence submission reads well, and it's nicely written, but that's only when viewed superficially. The committee should not be beguiled by this submission. It does not withstand critical analysis. For reasons that I will explain, the Defence submission is deeply flawed. It contains errors of fact, errors of law, and perhaps more importantly, it is grossly misleading because of both what it says and, more particularly, what it fails to say. The bottom line of the bill now before the committee can be summarised very succinctly. If it is passed by the Parliament, the sole beneficiary of the bill will be the Department of Defence, which will no longer be accountable to ADF members and veterans, their families and their supporters for the most significant decisions it takes in relation to the Defence Honours and Awards sought for ADF service. It appears that Defence regards its present obligation to explain and defend its adverse decisions as an unacceptable imposition. The unequivocal fact is that there is not a single provision in this bill that would generate any benefit for any ADF member or veteran, any of their ADF families, or any of their supporters. What's far worse, with only one exception, every operative provision in this bill would work to the clear detriment of every ADF member and veteran, their families and their supporters, because their present rights to seek merit review of adverse defence decisions would be either totally abolished or very significantly curtailed. The one exception in the bill that serves a public interest purpose is the provision that would require the Minister to table in the Parliament an annual report from the Tribunal. That would give the Parliament a regular opportunity to review and quiz the Tribunal about its performance. At present, we voluntarily prepare an annual report. We provide it to the Minister, but the Minister's, and we publish it on our website, but the Minister is not required to and does not table that report in the public. So I said that the defence submission is deeply flawed, and I should try to justify that for you. I think it can be readily demonstrated if I simply reference some quotations from the submission itself. The defence submission says, critically, these reforms do not diminish the ability of ADF members, veterans and their families from making applications to the Tribunal. This statement is unbelievable. Generously, it is simply an untruth. The bill would preclude all applications for review by members' families, veterans' families and other supporters in relation to defence honours applications. It would abolish applications for review seeking honours or for operational service awards or honours for service more than 20 years prior. And it would exclude all but very narrowly defined relatives in relation to defence and foreign awards. Overall, it would invalidate the vast majority of applications currently made to the Tribunal. The defence submission says that the bill refocuses current review application criteria to better support members and their families. That is errant nonsense. You do not better support ADF members and their families by abolishing or curtailing their rights to seek review of adverse defence decisions. As I said earlier, there's no substantive provision in this bill that would confer any benefit on any member, ADF member or veteran or their families or their supporters. The defence submission seeks to justify the proposed 20-year rule by saying that it is clear that obtaining records or testimony from people who witnessed honourable actions is increasingly difficult as time passes. But defence misleads when it fails to say that we routinely find reliable and probative contemporaneous documentary and eyewitness evidence in cases involving service in Vietnam over 50 years ago. And that cases still come forward where there is adequate and reliable information allowing confident decision-making in relation to service in the Second World War. The defence submission advances no credible justification for the 20-year rule. Moreover, the inference that ADF personnel cannot give credible evidence of events on their service if those events occurred more than 20 years ago is deeply offensive to those members and veterans. And the inference that the ADF's own contemporaneous records somehow become unreliable when they've been on file for more than 20 years is just ridiculous. The defence submission says on a number of occasions that the bill will not impact the government's ability to recognise eligible members with a Defence Honour Award or Foreign Award. And that's correct. But defence again misleads when it fails to say that the bill will also not impact Defence's continuing ability to refuse to recommend that an honour or award should be conferred. Those adverse decisions are currently subject to tribunal review, and Defence will no longer be accountable for most of them if the bill is passed. Defence will not be required to even inform the Minister, or more importantly, the Governor-General or the Sovereign, who in fact confer honours or awards, that it has unilaterally decided to reject an application for conferral behind its own closed doors. The defence submission says, ensuring that affected persons are at the core of applications for Defence Honours and Awards reviews is imperative for the well-being of members and veterans. Well, having regard to the well-being of members and veterans is a fine sentiment. But in what parallel universe can Defence even contemplate claiming that the well-being of its people is enhanced by stripping them of their present rights to challenge defence decisions that they believe wrongly deny them a Defence Honour or Award? The bill works against the well-being of defence personnel, notwithstanding that Defence says that is imperative. The Defence submission seeks to justify the limitation on standing to seek review of an adverse honours decision to eyewitnesses and other more senior in the chain of command on the claimed basis that honours decisions require an objective assessment of the actions of the individual under consideration in the context of the operation and the actions of others in the same operation. But this fundamentally misconstrues the nature of administrative review. In any challenge to a government decision, there is always an affected person who is self-interested and takes a subjective view. And often the government respondent does the same. The key requirement is that the reviewing authority, not the parties, must be able to take an impartial, principled and evidence-based decision. That is especially the case where defence honours are concerned, because the eligibility criteria are largely undefined and require very subjective judgment on highly conceptual terms, such as most conspicuous gallantry. In these cases, objective assessment is neither possible nor required. The defence submission says in relation to defence honours application that the bill ensures the member or their family are engaged in the process. This is palpably incorrect. Under the bill, ADF members, veterans and their families cannot initiate the process. At most, they can veto a process in the unlikely event that it is initiated by someone else. The defence submission says that an application to have a defence decision reviewed internally is a fundamental aspect of administrative law that remains available to all applicants. The bill does not displace that right. That's indeed correct. But defence again misleads when it fails to say that on every occasion on which the tribunal finds in favour of an applicant and the minister agrees with the tribunal, defence's internal review has failed to arrive at the correct conclusion. The defence submission says, in relation to defence and foreign awards, that there have been occasions where the tribunal has set aside the decision, directing someone, including defence, to reconsider the matter, which has resulted in the award still being refused. This is simply incorrect. The tribunal's never done that. Defence just exhibits a lack of understanding of the present legislation. The defence submission says that the bill modernises several components of the review arrangements and says that The bill enables regulations to provide for the conduct of reviews of reviewable decisions or inquiries conducted by the Tribunal. The intent is for regulations to be made to support the Tribunal with administrative matters that would better enable the Tribunal to deal with applications made to it. But if there was a genuine attempt to modernise the currently immature Tribunal governance and machinery provisions in the Act, it would be a simple matter to include appropriate provisions in this bill. The purpose of and established precedents for such provisions have already been identified and have not been challenged by the defence. They were set out in Attachment 7 to the Tribunal's first submission to the Committee's earlier inquiry. Instead, the bill introduces exceptionally wide powers to make regulations which could be used as much for malevolent purpose as for good. For example, the bill would allow regulations to be made to specify the kinds of evidence that may be taken into account for the purpose of a review. Now, evidence is either relevant or irrelevant. If it's irrelevant, no regulation is required to exclude it. It's apparent that this power could only be used to exclude relevant information, which would be a travesty of justice. And of course, the bill would allow the 20-year period to be reduced by regulation without limitation. Defence submission said that the Tribunal was consulted regarding the draft bill in 2024. That's highly misleading. In fact, what happened is that Defence told us what the Minister had already decided and that it would not revisit with him the concerns that we then raised because those decisions had already been taken.
Mr. Gill, I just want to say, how long have you got left? I'm just mindful of time that we've got to get to questions.
I have almost finished, Chair.
Okay, thank you.
Right. So Defence told us that there were around 40 versions of the bill. We only saw 7 of those. We never saw drafts of the second reading speech or the explanatory memorandum. I did have 3 brief conversations with the Minister during which he told me what he intended to do. And the Minister wrote to and obtained the Prime Minister's agreement to the core provisions that are now in the bill without any consultation with the Tribunal and well before the first of those conversations. The Tribunal has provided you with a detailed submission. It explains what the bill would not do, what it would do, and what its impact would be. Unlike the Defence submission, the Tribunal submission is populated by real live examples that demonstrate and support what it says. And the Tribunal submission clearly identifies what parts of the bill it cannot support, those few provisions that it can support, and alternative measures that might be contemplated if it was perceived that there was a problem with the present law that required legislative action, even though we say there's no real problem in that area. It's now, of course, for the committee to subject the Tribunal's submission to critical analysis. In doing so, I suggest that the committee might bear in mind the Tribunal is not a tribunal of general jurisdiction, a group of philosophically zealous administrative law proponents. Rather, the Tribunal is an expert specialist body that's in a clear position to know what it's talking about. The views expressed in the Tribunal submission are held unanimously by all its appointed members. 9 of those 11 members have extensive and esteemed knowledge and experience of military service across the ranks and across the 3 branches of the ADF, of military law and of military history. And the remaining 2 members have extensive and very senior knowledge and experience in tribunal governance and public administration. We say that ADF members and veterans who, with the support of their families and others, give their time, their careers, and tragically on occasions their lives in service of their country in order to keep the rest of us safe, fully deserve any and all medallic recognition for which they are eligible, whenever that eligibility can be established. and without any artificial limitation for the bureaucratic convenience of the Department of Defence. We say the underlying philosophy should be better late than never. In contrast, it seems that the position adopted by this bill is more akin to not now, not ever. Thank you, Chair. I'm happy to respond to any questions the committee may have.
All right, thanks a lot for that. I just wanted to pick up on a few things, and then I'll hand the call to Senator Collins. But just what you mentioned just before. Does the Department of Defence then provide you with evidence and other materials for each review that you carry out?
It does. We require them to provide, under our procedural rules, to provide us with a report that includes a merits review of the decision that has been appealed and all relevant documents.
And how many refusal decisions have you recommended be overturned?
I haven't got that immediately at hand. There are a whole lot of statistics in our...
Well, if you want to take that on notice.
Yeah, happy to take it on notice, but
okay.
Yeah, I'll do that and we'll get back to you later today.
Okay, cool. In terms of the 20-year limits, how far back does the tribunal usually review?
Well, at the moment, we can go back to September 39, the commencement of World War II.
Do you have an average?
How far we go back in any particular case depends on the service for which the veteran or member is seeking recognition. I would say in the majority of cases, the service in question is more than 20 years ago.
So on average, it's about 20 years?
I'd say it's at least 20. And as I said in my opening comments, we are routinely getting cases that relate to Vietnam service in the late 60s, early 70s, so more than 50 years. And we've currently got cases going related to service in the Second World War.
Okay.
One of the important facts is that when people are serving, generally the last thing they're thinking about is, should I have a medal? They're focused on doing their job, and if they've been nominated and knocked back, it is sort of against all expectation that they're going to try and challenge that while they're serving. Defence is a command and control organisation where you don't get people still serving, seeking to challenge decisions that have been taken by senior officers.
What would you see as a reasonable amendment, I guess, in terms of the 20-year limit that's been proposed here, like in terms of a much more lengthier period? Okay,
well, in our submission, what we've said is if there is a need to do something, and we don't think there is, we're still dealing with World War II cases with confidence, but if there was a need, it should be no less than 50 years. That allows for the full course of a defence member's service from age 17 to age 65, and a couple of years post-service to actually get the sort of the pluck necessary to challenge a decision. But if that sort of a limitation is going to be introduced, there would have to be a lead-in period, and we suggest 2 to 3 years, to let all people who would be whose current rights would be knocked off by that sort of reason to come forward. That would mean there'd have to be a significant campaign of information out into the ex-service community to tell people, if you think you deserve a medal or a member of your family deserves a medal, you've got to come forward in a reasonable time or that right will be repealed.
Okay.
But at the moment, anyone's got the right to go right back to 3 September 1939.
And just lastly, and just to provide me with some context, I understand there was a tribunal report. I think it was an inquiry into the recognition for the Far East prisoners of war. And as I read it, that I think the review or obtaining the evidence, some of the reviews of the World War II service, I think some of it was precluded after 2020. And I just wanted to get an understanding, was there a recommendation by the then previous tribunal chair source that evidence, or what were the reasons behind, I guess, not to say there's a change in views here, but why is it the tribunal back then was saying, look, it's probably too difficult to source evidence, but was there a now, in light of your position, would you be saying that you'd be open to reviewing that, or would you agree that reviews of the World War II service should be precluded after 2020?
The tribunal or previous members of the tribunal in one inquiry and the chair, a former chair in one letter to the Minister, did suggest a cut-off. They proposed different dates. The current members, in light of our experience in recent times, do not support either of those propositions in the terms in which they were put. Those propositions were put by those tribunal members at the time in the expectation that experience was going to show that there was difficulty in getting evidence. Our experience is, yes, there is some difficulty, you've got to work at it, but that's our job. And it should be defence's job to find the evidence too. It's in their files, and people are still alive who can speak to these events. But it's also important to say that on each occasion on which those propositions were put by former members of the tribunal, it was always with the proviso that there should be a significant transitional period that would allow people whose rights would otherwise be curtailed to come forward. This bill doesn't have any significant period before rights get abolished. At best, it allows 6 months, but legally, rights could be abolished a day after the bill was passed. There's no adequate transitional period in this bill.
All right. Well, I'll move the call along. Senator Collins, I'll come to you, and then Senator Lambie.
Thank you, Chair. And thank you, Mr Skehill. I'm just going to follow on from your answer just then. Will this bill affect the applications that you're currently reviewing?
The bill wouldn't. What is in process would still be able to, with the tribunal, would still be able to go through to conclusion. Significantly, though, there's hundreds, if not thousands, of cases out there where people have been told that they have a right of appeal. They have not been told that there is any time limit on when they lodge, and they weren't told because there wasn't a time limit. But if this bill is passed, all those people will be cut off at the knees unless they can lodge within 6 months of the defence decision. That's words fail me about.
You mentioned before that this bill will invalidate the vast majority of applications. Is that because of the time limit? Are the vast majority of these applications 20 years, related to events 20 years ago?
Okay, it's a combination of two principal facts. The period of service, if it's more than 20 years, those ones are out, would have been out. And the other principal thing is the standing. So if the application is lodged by someone who, say for an honour, who is not an eyewitness or a person in the chain of command, they'll be knocked out. if it's lodged by a family member who is not within the very closely defined definition of immediate family, they'll be knocked out. Let me just give you one classic example. The Sheehan case that I think everyone knows about, the applicant was the Tasmanian Minister for Veterans Affairs. He would not now be able to appeal to the tribunal.
Yeah, understood. And, you know, I find this bill absolutely, I think it's going to be absolutely disastrous for our veterans. And for the life of me, I can't understand why, you know, every single submission has rejected this, and yet the Department of Defence is still trying to run it through. And you described yourself as an expert specialist body, and you weren't consulted on this, and this is a bill that directly affects you. I'd just love to hear from you why you think the Department of Defence is so bent on getting this bill across the line. What's the motivation?
Look, I've heard people say the Defence just hates the tribunal and because it second guesses what Defence has decided, and Defence doesn't like being subject to external review. I don't know whether that's right. Defence don't say that to me. But if that was their view, they're unlikely to say it to me. My main interest in this is not to play the man rather than play the ball. I would much rather focus on the merits or otherwise of the propositions that are in the bill. And that's what I've been trying to do rather than sort of get down to personalities. I just think the measures that are in the bill are just wrong and not justified.
So, Mr. Skeagle, I've received a lot of correspondence about the Vietnam veterans that are, not qualifying for campaign recognition. Do you think that this bill is in part a solution to that problem, that it means that they will no longer be able to review that decision?
Well, it's not an answer to the what veterans seek. An answer to what veterans seek is to let them come to the tribunal and get an independent assessment of whether or not they're entitled to the medals that they seek.
Thank you. And my understanding is that the length of campaign is set at 181 days. Are you aware of any work to amend this or lower this?
No, I'm not. That's a matter for the department.
Okay, sure. I just want to bring it back to something you're asking before about, mentioned before about procedural fairness. Do you see this as rejecting the rights to procedural fairness for veterans?
Well, I suppose in one sense the bill does not attack procedural fairness as such. Anyone who's entitled to make an application will get procedural fairness. But because it knocks out the right to make an application, it means that those people who can't apply will not get procedural fairness because they will not get independent review on the merits of a decision that they believe is wrong.
Thank you. And final question from me. Item 8, number 76 in the explanatory memorandum describes how one of the changes will be that a decision regarding previously cancelled Defence Honours awards or foreign awards will not be a reviewable decision. It will therefore be a decision of the Crown, a political decision. Are you concerned about that particular clause?
Okay, well, we've dealt with that in our submission to you. At the moment, if someone has an honour award withdrawn, they cannot appeal the withdrawal decision. What they can do is apply for reissue of the withdrawn honour award, and if the reissue is refused, they can come to us. We think that's, and look, we haven't had any of these cases, but read the press. It's not beyond possibility. We think that's a very undesirable situation, because if in that circumstance we'd be called upon to effectively be reviewing a decision that had already been made by the Governor-General or Sovereign. In our submission, we've suggested that the far preferable course, rather than completely saying to those people, you have no right of appeal, these decisions can be made with you having no external recourse, we think it'd be far better to have the tribunal part of the show cause process, as it were. So someone who, where it was proposed to withdraw their honour award, would be given an opportunity to, before that decision was taken, to apply to the tribunal. The tribunal could review, and the tribunal may well agree that the honour award should be withdrawn. Alternatively, the tribunal may find that there are other compelling reasons why it shouldn't. The Governor-General or the Sovereign would then be better advised, and the person affected would know that the eventual decision had been taken after some external independent review. We think that'd be a preferable way to deal with it than the current process. The bill doesn't do that. It just says whenever a decision is taken to cancel or withdraw, that's the end of it.
Okay, sorry, very quick final question from me. You mentioned before that your amendment would be no less than 50 years on the time limit, but would that not preclude quite a number of the Vietnam veterans who would now be in their 80s?
Yeah, but the important point about that proposition, and we're not sort of arguing so much for that, but just saying if it is perceived that something has to be done, this is a way forward. The important part of any amendment of that nature would be there would be a period of years where people with older service, more than 50 years, would be told in very public terms, if you think your service more than 50 years warrants a medal, come forward now. You've got 2-3 years to come forward. If you don't come forward in that period, that's the end of the matter. So there'd be that sort of a transition period. And hopefully, if that process of public engagement was done properly, no one would be seriously disadvantaged.
Okay. Well, thank you so much for your very strong statement and evidence today, Mr. Skihill, and thank you for everything that you do to seek recognition for the veterans. Thank you, Chair.
Thanks a lot, Senator Collins. Senator Lambie, you have the call.
Oh, thank you, Chair. Can you hear me?
I can. Yep. Very good.
Great. Thank you. Thank you for your statement, Mr. Skillett. That was very interesting. I'm sure you've heard from everybody else out there that every digger, that including myself, is highly offended by the bill in the first place, to be brutally honest with you. And I think that goes to show, you know, when you've got all those submissions and the only one that believes that it is correct is the people that done it themselves, which would be defence. And that I think we find even more offensive after going through a Royal Commission for 3 years. So have you got any idea, apart from, I know you heard, you did say a few things, did touch on it, what's defence get to benefit out of this? I mean, to be honest, I don't know if the committee knows this, but considering there's just on about 24% officers in the military, they take double the amount of medals than what the diggers do. Is this going to actually give them a more stack of medals than what it is those diggers, is it? I've got the statistics and that here, and I can tell you it's well over the halfway mark that the majority of those medals go to officers.
Well, the bill itself wouldn't have that effect, but what it would mean is that people who didn't get a medal and thought they should have got a medal would lose out their current right to challenge that decision before the tribunal.
No, I understand that, but why are they doing it? What's the point behind it? I think that's why we're all sitting here for the next 3 hours going, I think, majority of us in agreements, we don't understand why the bill's going through. So I'm just trying to see whether I've missed anything with everything you've said this morning on why this bill has been put up. I don't get it.
Senator, I'm not wanting to be difficult, but you've got to put that question to the department. They don't confine to me why they're doing this.
Yes, I'm going to. I just thought maybe with all your experience, you might have been able to pull one off the right side there for me and get in a bit earlier, honestly. Because until I find out why, I just don't know how, how I can possibly ask questions, to be brutally honest with you. I'm in disarray about why they're trying to do all this.
Yeah, well, to some extent, I'm in the same boat as you. I don't understand why this bill is in this form. It is a mystery.
Okay, I have no further questions. Thank you, Chair. Thank you so much for coming in. Really appreciate it.
Okay, thanks very much, Senator Lambie. Senator Pocock, I understand you have some questions.
Thank you very much, Chair. Good morning, Mr. Skill, and thank you for your comprehensive submission to this committee and for the work that you do at the Tribunal. We've talked a bit about the lack of consultation, but just going to the Minister for Defence Personnel's second reading speech, and I want to quote, "The Tribunal was consulted throughout the development of the bill, and while not all its specific recommendations have been adopted, its input has been invaluable in shaping the legislation, which seeks to largely achieve the same aims as the Tribunal's recommendations." I'm interested at what point were you consulted? Before they decided to go ahead with the bill, or was it very much, this is the bill we're going to do, give us your thoughts?
We were consulted and I don't know that consulted is exactly the right word. Consultation, in my understanding and looking at dictionaries, involves interactive two-way discussions. We were told that there was going to be legislation that would embody what are now the core provisions of this bill after the Minister had written to the Prime Minister and gained consent to those core provisions. And as I said in my opening remarks, some months after that, Defence started providing us with information and a draft of the bill. We raised concerns with the provisions, and Defence said to us, well, those things have already been decided. We're not going to challenge the Minister on those. And the process went on. There were about 40 drafts of the bill. We saw 7 of them. We provided detailed commentary to the Minister, but the bill went ahead.
Mm-hmm. Okay. Thank you. So, I take from your evidence that really wasn't a true consultation process. One of the things I wanted to ask about was in your submission, and you've mentioned it in evidence today, that if this bill had been in force at the time, Ordinary Seaman Teddy Sheehan would not have received the Victoria Cross for his actions in HMAS Armidale. For the benefit of the committee, can you just explain why? Like, what effect does this have in terms of the process? And do you think there's potentially others out there who this would preclude from actually being nominated and potentially being recognised for their service?
Okay. So Teddy Sheehan that case would be impossible under this bill because the service was more than 20 years ago, well more, and because the applicant for review was not an eyewitness to the events or a person in the chain of the command. As I said earlier, the applicant in that case was the Tasmanian Minister for Veterans Affairs. So double strike, that case couldn't go ahead. And in our submission, we've detailed a whole series of other cases that would equally be impossible under this bill. Really significant cases. The most recent one, Richard Norton, VC, but a stack of others in there. And it's not just the high-profile cases that we ought to be concerned about, just ordinary serving members who do remarkable things that would be knocked out by this bill.
Well, thank you, Mr. Skill. And I want to echo some of the sentiments of my colleagues in saying I don't really understand what the government is doing with this bill and why they're prioritising it, given the other big challenges we face when it comes to veterans and defence. Just finally, are there issues with the tribunal that you do feel need to be addressed, and what approach should we take with them?
Look, there's certainly improvements that could be made, but I think none of them are earth-shattering and none of them are particularly urgent. But if you look at the legislation that relates to the tribunal and then compare that with the legislation that relates to, say, the Administrative Review Tribunal or any of the state equivalents, our provisions are very immature. There's not even a statement of purpose of why the tribunal exists in the legislation. We don't have the sort of machinery provisions that we'd like to deal confidently with applications that people want to withdraw, or the grounds on which the chair should be able to dismiss an application and so on. Mechanical stuff. In attachment 7 to our previous submission, and Chair, I might send that through again later today so that you've got it readily to hand. There's a whole raft of provisions that we would like to see. Defence hasn't argued against any of those. They're just not in the bill. A contentious one is the time within which people should be allowed to lodge an application for review. So at the moment, there's no time limit. A decision could be made today by Defence, and the individual could come in 10, 15, 20 years later and seek review of it. That's very generous, but it also has a downside. 10, 15 years' time, that we may not be able to get as readily the evidence that you'd get if you could deal with it today. The bill says you have to appeal within 6 months. Now, we think that's relatively generous. Most administrative tribunals, you've got to appeal within 28 days. The bill says that we should have a capacity to extend the period of 6 months in exceptional circumstances, and we think that's good. I mean, a lot of our applicants are in ill health, often service-caused ill health, and trying to expect them to come forward within a set time period in a particular case might be a bit unreasonable. But it is better if we can get to do the review closer to the time of the decision, when documentary records are still readily available, and more importantly, when the veteran, the member, the applicant, witnesses are still current. So there's a few things like that.
Sure.
But look, is there anything earth-shattering that needs to be done immediately, or the system's going to fall over? No.
And just finally, in terms of the system, one of the submissions I looked at was from a person who's helped 8 people make an application to the tribunal relating to service in Vietnam. In 7 of the cases he assisted with, the tribunal recommended defence's decision be overturned. And this person is suggesting that there's actually a problem in defence's processes, not in the tribunal's processes or constitution. And I'm interested how many decisions the tribunal is overturning, and if you have any reflection on where defence may be going wrong if there's so many decisions being overturned.
Okay, I think you're about to hear from the person that made that submission later in the day. And interestingly, I think all of the cases that he's brought forward would be invalidated by this bill because he wasn't an eyewitness or in the chain of command. But he did, marshal the evidence, and he's had a strong success record. Why? At the moment, applications for review, we send them the defence asking for a report. About 1 in 3 at the moment, defence change their mind and give the applicant what they want. They recognise that the decision wasn't sustainable and they don't try and contest it before us. The ones that go to hearing before us, about half are successful and half we think defence got it right. They're rough figures. Sometimes defence, we think, just has not adequately analysed the evidence. Sometimes we think defence has got the law wrong, and sometimes it just boils down to what's essentially a subjective judgment about what some of the eligibility criteria mean. For example, what's the most conspicuous gallantry as opposed to ordinary gallantry? They're very difficult terms, and people can have legitimate different views about that. But let me give you one example of where we think defence got it clearly wrong. There was a gentleman who was seeking recognition for distinguished service. For particular events in Afghanistan, he gave defence helmet-worn camera footage of those events. The defence decision maker didn't even view the footage. We asked for it. Defence said, we'll give it to you, but you want to be careful watching it. It's very, very, very challenging. We viewed the footage and we thought it made a very clear case for distinguished service. So, look, defence takes thousands of honours and awards decisions in the course of the year. Most of them are either right or not challenged. It's only a few that come to us, but the few that come to us are very important. And sometimes they're terribly significant, not just for the individual, but for the country. For example, Sheehan, Norden, and cases like that. A number of the Vietnam cases.
All right, thank you. Senator, do you have any other questions for the witness? Okay, now Senator Lambie and then Senator Whittaker, and then we'll have to wrap up with this witness, unfortunately.
Thank you very much. I was just wondering if you may be able to provide me with copies of any of the correspondence that you've had, or to the committee that you've had with Defence and the Minister's Office over this subject. Would you be able to do that, please?
Senator, I'd be happy enough to do that, but I would like to consult the Minister before I gave you copies.
That's okay. I'm going to FOI it anyway, mate, tell him, so we're going to get it one way or another. Thank you.
All right. Thanks, Senator Lambie. Senator Whittaker, you have the call, and then we'll wrap up.
Thank you, Chair, and thank you, Mr. Skill, for your evidence this morning. I just wanted to ask a couple of very brief questions about the award for Ordinary Seaman Sheehan to award him the Victoria Cross. I note he's been mentioned a couple of times, that award has been mentioned a couple of times in the hearing this morning. When did the Tribunal recommend the awarding of the Victoria Cross to Teddy Sheehan?
2019, I believe.
And my understanding is that the government of the day did not accept that recommendation at the time. Is that your understanding?
Yeah, that's certainly my understanding, and it's more than an understanding, it's a fact. The government, the Chief of the Defence Force, recommended that the Tribunal, this then Chief, recommended that the decision of the Tribunal not be accepted. The Minister for Defence, then Minister, agreed, the then Prime Minister agreed, and supporters of Teddy Sheehan continued to lobby, and eventually the government set up another committee to review the matter, and that committee came to exactly the same view as the Tribunal, and eventually Teddy Sheehan got a very richly deserved Victoria Cross for Australia.
What reasons did the government provide to the Tribunal for establishing that one-off panel that you refer to?
I was not on the Tribunal at the time, but I don't know that the government actually gave any reasons to the Tribunal.
Okay. Thank you. That's all my questions, Chair.
All right. Thanks a lot. No other senators had any other questions? Otherwise, can I say thank you, Skill. Thank you for your submission and for your evidence this morning. I think there were some questions that you did agree to take on notice, and we would appreciate any responses to them by Tuesday next week, 12 noon.
Not a problem, Chair.
Okay. Thank you very much for appearing today. We'll move along now to our next representatives or witnesses for today, and we've got representatives from RSL New South Wales and TPI Federation of Australia. Good morning, and thank you for your patience. For the Hansard record, could I just ask that you all state your full names and the capacity in which you appear today, and I'll start with RSL New South Wales.
Thank you, Chair. David McCann, Deputy Chair, RSL New South Wales.
Isaac Olin, General Manager, Policy and Services, RSL New South Wales.
Scott Jeffrey, National President, TPI Federation of Australia.
All right, thank you very much, gentlemen. Now, I understand if you have provided opening statements, we'll circulate them to the committee members for their review. But was there anything that you wanted, in addition to those statements, for about a minute that you wanted to raise? Otherwise, we can get straight to questions.
No. Senator, no, we'll take those.
Okay, all right. Now, senators, who'd like the call? Senator Lambie, did you want to kick off? Thanks.
Can you hear me?
Yes, we can now.
Good. Good morning, gentlemen. What are your thoughts in a few words without me? I mean, I've been through your notes anyway, but is there anything you want to say this from your personal self as a serving member, or you want to get off your chest? But is there anything else you'd like to add that's probably a little bit more personal about what's going on here?
Senator, if I could start off by just saying it's disgraceful. RSL New South Wales is extremely disappointed. We're obviously a large organisation and we represent over 30,000 veterans. To a man and woman, they've expressed their disappointment at this. We are managing a number of current claims by veterans in relation to their service dating back well before 20 years. And we just feel that this bill will be completely detrimental not only to their mental health and their physical health, but it also devalues their service.
Does anybody else want to add anything? Scott, do you have anything to say, Riso?
Yes, Senator. This is affecting, obviously, the cohort of East Timor veterans backwards when we start looking at the 20 years provision. And being a younger veteran myself, it's hitting hard with my mates because I was in the battalion that was deployed to Rwanda. And seeing them come home, especially after the Kabayo massacre, completely different men from Bravo Company 2 area, it just basically disgusts me that we're talking about 20 years for cut-off. There should be no cut-off for time if we can provide the actual evidence. And what people don't are misunderstanding is that even when you get older, your memories become stronger for the issues that actually have affected your life in a harder way. I'm receiving information from Korean veterans from the Battle of Kapiong, what occurred, that's not even in the war diaries of 3 area. So there's these things that are starting to come to the forefront too. That's it. Thank you, Senator.
Oh, I hadn't thought about that. Thank you. I hadn't thought about putting that in the mix. Triggering for them and things start. Yeah, that's interesting. I had not thought about that. Thank you. Isaac, do you have anything you want to add?
No, thank you, Senator.
Is there any bit of this bill that you think is any part of it worthwhile at all? Or are we all just sitting here wasting our time? Is there anything in there that you think, and is there anything urgent out of that about this bill?
Not that we can see, Senator. I think there are far more important issues confronting the veteran community that we should be working on and talking about. This seems to be some sort of administrative tidying up to make a problem go away. But it's important to note that the cohort of veterans that we're talking about are getting older, but that doesn't diminish their pride in their service, and they need the opportunity to be able to argue their point and seek that service recognition.
See, I would have thought they were using this as a distraction instead of getting on with the Royal Commission recommendations, because seriously, I don't know why this is not on top of the list when we've still got all that sexual abuse going on, that nothing has changed since the last time I did DLA Piper 12 years ago. I would have thought we would be doing things like that to make a difference in people's lives. So I actually have... I have no further questions. But if you want to add, please do so, because that's what I thought we would have been doing after coming out of that Royal Commission.
So can I just open up on the question that you just asked? Yes, there is absolutely nothing in here that we should be sitting around wasting our time today on. The 20 years we don't agree with. There is a big cohort of veterans coming through that have been in the ODF in Townsville, that have been exposed to all these things. And if you start looking at the 20-year process, you're starting to remove meritorious unit citations. You're starting to lose unit citations for gallantry, such as for the Battle for Balmoral, Long Tan. Then we start looking at the when they change the conditions of service from non-warlike to warlike, aka Rwanda. So then we've got to look at the battle, if there's any honours and awards that need to come out of Rwanda because of the change of conditions of service. So there's a lot that is missing, and there's a lot that we need to talk about, but there is more pressing issues that we need to speak about other than the medallic side of things at the moment.
Okay, can I just ask one more question, but can you tell me whether any of you three were consulted and how much consultation was done between yourselves and I don't see Defence consulting with you, but was there any consultation from the Minister's office, especially being the New South Wales RSL? I know you guys hold your own, but I mean, you're a big organisation there. Was there any consultation with you guys?
Not that we're aware of, Senator.
Absolutely nothing from the TPI.
Okay. Thank you. I have no further questions.
Thanks, Senator Lambie. Now, Senator Collins, and then I'll go to Senator Whittaker. Senator Collins.
Thank you, Chair. I've got a few questions for RSL Australia first. I'm just wondering whether you believe the bill will diminish veterans' rights and what sort of impact you think this might have on their mental health.
It's RSL New South Wales, Senator. But yes, in response to the question, we have deep concerns on the impact it will have on veterans. We're talking about circumstances where a number of veterans who have left service and have drifted away from the ESO community that are starting to come back, and they're asking the ESOs to help them with these issues. And in some cases, veterans wait years before they put their hand up. And so to have a time limit, as has been highlighted, of 20 years put on these things is simply impossible. It won't work, and it's going to cause more stress within the veteran community.
Yeah. Your submission is notably more critical than that of RSL Australia. Can you just outline the key differences between your positions? Have you read RSL Australia's submission?
Yeah, RSL Australia, whilst we're a federated body, has their own views on some of these issues. Our position in New South Wales, and as I said, we represent over 30,000 veterans. We believe in acting on the feedback we get from our members through our sub-branch network, and we have had overwhelming negativity on this bill, and we fight for and argue on behalf of our members.
So I guess the fact that you weren't consulted on this is just indicative of the fact that Department of Defence would have seen that pushback coming?
I think so, Senator. I think there is no reason why there's such a rush to put this through, other than to, as was mentioned before, a distraction from the real work that needs to be done on the Royal Commission.
So you also noted in your submission that the bill appears to erode the Tribunal's independence. Why is the Tribunal's independence from government and defence so essential?
Well, I think primarily the trust position that the veteran community has trust in an independent tribunal, considering all of the facts and reaching an unbiased conclusion. There will be times, of course, where the veteran community disagree with the tribunal's findings, but there are mechanisms in place to appeal those. There certainly needs to be some work done in that area, but generally speaking, the trust and independence of the tribunal is the strength of that organisation.
Thank you. Final question. Many ex-service organisations and RSL sub-branches have called for a full repeal of the bill in their submissions. Do you support that?
Yes, I do, Senator. Yes.
Thank you. And a question for TPI Federation. Do you believe that introducing this bill unexpectedly and without prior consultation with the veteran community may have caused distress amongst some veterans and advocates?
Senator, the answer is yes. Not having the ability to see what's coming down, see what's coming towards us, is making it. And I am a trained advocate, so I do advocacy on the side as well as being the national president. And there are people that are from the Cambodia, Rwanda, Somalia cohort. So we're talking the early 90s. That have, if this was in place, and they've only just heard about this through the mates system, the soldier network, is that that their MUCs or meritorious unit citations wouldn't have been approved. It would have fallen just outside of the 20-year mark. So yes, there is issues in there. There's issues around the Timor vets and if there's anything going to happen with the Solomon Islands, because that is falling within inside the 20 years now. So yes, there is the answer.
Thank you. And in your view, and anybody else can respond to this as well, is there any justification for making the changes to the tribunal as it currently operates?
No.
No.
Okay. Thank you so much. And thank you, Chair.
Thanks a lot, Senator Collins. Now, Senator Whittaker, you've got the call.
Thank you, Chair, and thanks for appearing today, both RSL New South Wales and TPI Federation. I've just got a couple of brief questions. I guess a kind of more general question to start off with. Do you view Defence Honours and Awards as particularly unique to other kinds of awards and honours that are provided? And if so, what makes them unique?
Well, I think the short answer, Senator, is yes. They are significant, and not only to the veteran, but to the veteran's family. When a veteran's passed on, they're a tangible way of remembering that person and the sacrifice that they've made. And irrespective of what the medal is or award is in defence, it doesn't have to be a gallantry award. It can simply be a campaign medal. It's important to that veteran. It's a part of their life.
From the TPI's point of view, and a personal point of view, being a fifth-generation veteran, war veteran, having the medals or the medallic recognition of what's occurred actually paints a picture for your family. So it's not just the medal itself; it is the stuff. It is the stuff that comes with it. So you're talking about. So I can pass on to my daughters my 5 medals, but they know where Dad's been. They know these other things, but we've got to make sure that we differentiate between campaign medals and medals like the UN compared to the conspicuous, the meritorious and the gallantry medals as well. Okay, so there's 2 different parts in there. So yeah, there is a big thing, and yes, there is. Thank you.
And how important is it that there is, I guess, integrity in the process for both applying for these awards and honours and then reviewing those decisions when required?
I think from my experience, Senator, and from an RSL New South Wales perspective, we have taken on a number of cases from veterans through our sub-branch network and beyond the RSL, going back some years, claiming recognition of service. The process is respected. It can be laborious, but that does occur when you have to go back through records to justify. But we're dealing with a number. One that comes to mind is 4RAR, the service in Malaysia, and that's going back well past the 20 years that we're talking about. The problem that we find with the process is that the records available are somewhat limited, and there's a reluctance to take the word of not only the veteran, but that we're living the senior officers that were involved in the process, which we find concerning and disappointing. But as I say, that's more to do with the process than the feeling of the system.
Is there anything you'd like to add, Mr. Jeffrey?
Just that the tribunal obviously has the need within inside what we do, and the integrity of that of the tribunal needs to be kept. If we start going down on watering down their terms of reference will start getting people with the old, what they used to call it, the stolen valour. So we've got to make sure that we keep our honours and awards system at the highest degree. We've got to make sure that it's intact and the integrity of that system is maintained to ensure that when we do present, or when our country does present these medallic awards to these people, it is done for the right reasons.
Do you think it's appropriate for individuals to nominate for themselves for an honour or award?
I think it should be their right to do it, Senator. It would depend on what the award is. So obviously, there is a need for some sort of collaboration with any nomination. But I think it's within a person's right to nominate. Whether or not it is processed through, I can't say.
Just with that one, Senator, no. However, there could be circumstances where it could occur if there's no other, obviously, people, witnesses around or anyone to call upon. But 99% of the time, I have not seen a person nominate themselves for an honour or award.
A final question goes to the time frame for review of a decision by the tribunal. So the bill, of course, has a time frame in it of 20 years following the end of an operation or service. What do you think would be? Is there another period that you think might be appropriate if 20 years is not the right time frame?
Senator, I don't understand what it seems the system is working now with that
Not sure if anyone else is having problems hearing Mr. McCann.
We are. That's okay.
Yeah, okay. It's not just me.
I think you may have dropped out too.
I can further on that one. There is the time frame itself is a bit of a weird one, because after you finish an operation, you have your hot wash or your end of war after action report done by defence. Within that should come out, and I've sat through one of these myself, should come out all outstanding honours and awards that had not been approved or had been knocked back. That's when they should start looking at what's going on there. With inside the 20-year time frame, I don't believe that there should be a time frame put on it whatsoever. That's my personal opinion. But from the TPI, it's 100 years. And that goes back to using the caveats of cabinet and confidence, using secret stuff. If we're talking about our lovely friends from WA that are doing the secret squirrel stuff, you're not going to hear about what they've done, and you're not going to see what's going on. So there's other ways and mechanisms that we could actually look at different things. But the 20 years is not conducive to anyone.
Just to clarify what you've just said, Mr. Jeffrey, you mean 100 years from the end of an operational action, not 100 years of age? Okay, yeah. Thank you. That's all my questions, Chair, unless we've got Mr. McCann back.
Anyone else? Any other senators with questions? Mr. McCann, you're back.
Yes, apologies. I'm in rural New South Wales, Chair. Internet's very slow out here.
That's all right. I don't know if there's anything you needed to supplement there for Senator Whittaker. Otherwise, I'll just say thank you very much for all appearing today. And if anything that you were taken on notice or asked to take any questions on notice, please provide a response by Tuesday next week by 12 noon. Now, we'll just take a short suspension while we get ready for our next witness. everyone. Now, I'd like to welcome Major General retired Greg Mellick, National President of RSL Australia. I understand that information on parliamentary privilege and the protection of witnesses given evidence to Senate committees has been provided to you. Now, for the Hansard record, could you please state your full name and the capacity in which you appear today, please?
Aziz Gregory Mellick, National President, RSL Australia.
Thank you. Now, do you have something brief to say at the start of this slot as well as an opening statement, Greg?
Well, you should have already received a submission from RSL Australia.
Yes, we have received your statement, the submission, but was there anything you just needed to add briefly before we kick off with questions?
Well, our fundamental position is this, that there must be a right of appeal in relation to these awards, independent of defence.
I've lost Greg. All right, we'll just try and get Mr. Mellick back online, everyone. So we'll just have a quick suspension there. Please, Petita.
We're ready, Chair.
Thank you. All right. Sorry, Mr. Mellick, off you go again.
I just want to emphasise in addition to the submission we've already put in, that the Honours and Awards Tribunals worked very well in the past. Veterans are concerned that any review by defence will not be independent, and therefore they're very keen to keep the independent review process we now have. We appreciate there's a problem with the length of time granted for submissions, and perhaps the 20 years is not long enough, and make it 40 years, but after a grandfathering period to allow people with older submissions to put them in, and as long as the submission is put in before the end of the grandfathering period, the new limit of what we suggest should be at least 40 years comes into effect.
All right. I'll hand over the call to I'll come to Senator Collins and then Senator Lambie, and then I think Senator Pocock. So Senator Collins.
Thank you so much, Chair. And thank you, President. I was just wondering if you could, if you believe that the bill will diminish veterans' rights and lead to poorer mental health outcomes.
Yes, I do. I think there's been, as to whether or not it's justified, there is a long-standing distrust of veterans or certain segments of the veterans community to defence. It has certainly contributed to mental health issues. That is their perception, whether it's true or not, has contributed to those mental health issues. And bring into place a system whereby a veteran's rights and entitlements to honours and awards is determined by defence rather than independent tribunal will only exacerbate those mental health issues.
Thank you. And your submission mentions that RSL notes that the intention of this change is to increase the tribunal's focus on specific contemporary periods. However, the tribunal itself indicates that its current workload is manageable. So do you think that if the tribunal can effectively manage its workload and the existing applications without the bill's proposed limitations, do you think that no changes should be made?
The only change I consider appropriate, and once again after a grandfathering period, is a time limit. I'm not so much concerned about the workload for the tribunal. That's something that can be always adjusted administratively by increasing the capacity of the tribunal. But the problem is that people's memories do fade with time. And once you go past, say, 40 years, you really are running into the danger of having people's memories being conflated, and it may in fact diminish the credit or the credibility is probably not the right word, but the integrity of the particular honour being considered.
Many ex-service organisations and RSL sub-branches have called for a full repeal of this bill and their submissions. Do you support that position?
I don't see the need, apart from some minor amendments, I don't see the need for the bill. I don't see the need to get rid of the current processes which allow independent review of honours and awards.
Okay, and prior to this bill being introduced to Parliament, did your organisation have any concerns with the conduct of the tribunal?
No.
Thank you. And during your organisation's discussions with members and representative bodies, has the conduct of the tribunal been a prominent issue at all?
No, our members consider the tribunals worked very effectively.
Thank you very much. And are you aware of any problem the legislation is actually trying to fix?
I think there is a problem about revisiting actions that occurred in the far distant past. You get the occasional exception like Teddy Sheehan and to a lesser extent Private Norden. I personally am concerned about the integrity of a system which, when you start relying upon people's memories for events that occurred 50, 60 years ago, when the people trying to recall are going to be in their 90s, I think there's got to be some limits. As I say, after a grandfathering period, allowing for people who have a particular issue they want to push, time to get the application in, and after which we close it off and say, right, 40 years is it.
Sure. They are very impactful events as well, which I'm sure people hang on to the memory for a very long time. In your opinion, does Defence always make the right decisions in relation to metallic recognition?
I can't comment on that. I haven't analysed Defence decisions in relation to particular methods. I note that Defence's position was overturned in relation to Private Norden, and to a certain extent in relation to Teddy Sheehan. At the end of the day, as to whether Defence was right or the Tribunal was right is not really a matter for me. The point is we had an independent review process. That was the Tribunal. They made a decision and we're content with that decision.
But just following on from that, from your perspective, did the veterans community strongly welcome the awarding of Victoria Crosses to Teddy Sheehan and Richard Norden?
I can't comment on behalf of the veterans generally, but I know it was well received. Both were well received, but as to what extent within the community, I'm just not aware.
Okay. Are you able to comment on whether they value the opportunity to appeal decisions made by Defence? Does it provide a sense of justice or procedural fairness?
Yes. No. Yes to both of those.
Yes. Okay. Thank you so much, Chair, and thank you so much, President.
Thanks a lot, Senator. Now, Senator Lambie, you have the call.
Thank you. Mr. Malik, how much consultation did either Defence have with you or the Minister's office in relation to this bill?
There was no consultation from Defence. There was consultation from the Minister's office. We were made aware of the bill and given the opportunity to make submissions.
Okay. Is there any other correspondence outside of that between yourself and the Minister's office in relation to the bill? If there is, could you please pass that correspondence over to the committee?
I don't have any in front of me at the moment, and a lot of the correspondence would have been done by our NVAC committee rather than me, but I can make inquiries and come back to the committee with any correspondence.
That'd be wonderful. Thank you so much. I have no further questions. Thank you.
Thanks, Senator Lambie. Now, Senator Pocock, do you have a question?
Yes, thank you, Chair. Major General, thank you for your time and thank you for your service. Looking at the minutes, I understand that you were at the ex-service organisations roundtable meeting on the 27th of August last year. Do you recall that? Does that sound correct?
Senator, I'm sorry, but I can't, if the minutes have me there, I was there. I've attended so many meetings, over the last 6 years.
No, I understand that. That's fine. I have downloaded the minutes from that meeting, and according to the submission made to this committee by Legacy, the minister appeared at that meeting to discuss proposed changes to the tribunal. But from what I can read, no one was left with the impression that there would be a bill to make changes. And I'm happy to maybe table these minutes so other senators can have a look. But I'm just interested. I understand you attend a lot of meetings, but do you recall at that meeting whether the minister talked about legislation to change these issues that were discussed?
No, I'm sorry, Senator. I can't even recall being at the meeting, let alone that what might have been discussed there.
Fair enough. Have you had any meetings specifically with the minister to discuss this bill?
No, not specifically discuss this bill. I've had meetings with the minister to discuss veterans issues generally. I think the only discussion I've had with the minister in relation to this bill would have been by telephone, because I don't recall physically meeting in relation to this particular bill.
Mm-hmm. One of the themes through most submissions is the lack of consultation. I'm just interested if you could maybe reflect on how you think RSL has been consulted, whether you think it's adequate, and maybe what you'd like to see in the future if not.
That's a difficult one, Senator. I was aware that the bill was being considered. Mm-hmm. I indicated that it would not be supported by the RSL, but I wasn't given much detail, and I can't recall being specifically told by the minister or his staff, because obviously a lot of the times this would be matters that be raised by the minister's staff rather than the minister himself.
Sure. And
what I'm saying, I think I was mildly surprised when the bill came, because it was in a form and dealt with matters I wasn't fully expecting. Mm-hmm. And I certainly wasn't expecting the removal of the right to an independent appeal, removal of independent appeal rights.
Mm-hmm. Thank you. And then just finally, do you recall if the phone call you received from the minister or his office was before or after the bill was introduced to Parliament?
I don't, but in line with the minister's usual practice and interactions, it would have been beforehand. Okay. There have usually been very full and frank discussion between the minister and I on all sorts of matters, and we often disagree, and he always listens. Then makes an appropriate decision. Sorry, makes what he considers to be an appropriate decision, mm-hmm. which isn't always a decision which I've urged upon him. Mm-hmm. Well, but I have to say the relationship between the minister and the RSL has been very strong and very good. He's been particularly consultative. This one, I must admit, there seems to have been less consultation than I normally expect.
Mm-hmm. Well, thank you very much. Appreciate you showing up on your last day. Thanks, Chair.
All right. Are there any other questions? And if there's anything okay, well, thanks, Mr. Miller. Can I also, just follow on from Senator Pocock, just also wanted to say on behalf of the committee, thank you for your distinguished tenure as National President of RSL. I understand today is your last day, and it's very fitting that you're able to squeeze in between your board meetings and other commitments today to appear before the committee. And I guess we wish you all the very best with the next chapter of your life, and the very strong leadership, good humour, I must say, and also absolute commitment to the service that you have made to many veterans around the country. It will have a lasting impact, and on behalf of the committee, we wish you all the very best, and hopefully you don't get too much of a grilling at your AGM.
Thank you, Senator, and we do appreciate the interest the committee has taken in listening to submissions from the veterans community generally, as well as the RSL. It's been much appreciated.
Indeed. All right. Well, on that note, colleagues, we are going to break, and we'll return at 1:30 p.m. for once we've returned from the lunch break. But we'll suspend to 1:30. Thanks, everyone. All right, welcome back, everyone. I now would like to welcome a number of individuals today. I understand that information on parliamentary privilege and the protection of witnesses given evidence to Senate committees has been provided to you. For the Hansard record, could I ask that you state your full names and the capacity in which you appear today? And I'll start with the gentleman in the room. George, do you want to start, please?
Yes, my name is George Leslie Hulse.
And Richard, you're online?
Yes, Richard Joseph Barry, B-A-R-R-Y.
Now, do either of you two gentlemen have an opening statement or a short statement you'd like to make?
Yeah,
Yes.
I'd love to if I could, please.
I also
All right,
have
let's
an
start.
opening statement.
Okay, I'll start with you, George, and then I'll come to you, Richard.
Okay.
All right, Mr. Hulse, you have the call.
My name is George Hulse, a veteran of Malaya, Papua New Guinea, Vietnam and Kashmir. My aim is to describe the value of the Defence, Honours and Appeals Tribunal to veterans such as myself and ask you to support us in defeating the Defence Amendment DHAAT Bill 2025. I advocated for 8 ADF personnel of the Vietnam War era to receive retrospective honours and awards by applying to the Directorate of Defence Honours and Awards on their behalf. Every last one of them was rejected by Defence. I appealed for a reviewable decision with the DHAAT, and on the Tribunal's review, 7 out of the 8 applicants were accepted to receive retrospective awards. Clearly, something is wrong with the defence process of determining retrospective awards. I intend to give an example of one of my advocacies in Private Richard Norden VC and go on to explain that if the current amended DHAAT Bill 2025 had been in action when I commenced this process, veterans such as Norden would have never receive their overdue recognition. If this bill passes successfully through Parliament and becomes law, it will be impossible for Australian veterans of wars prior to those of the Iraqi and Afghanistan conflicts to seek a reviewable decision. I intend to oppose this bill because, in my opinion, it is regressive, restrictive, and an anti-veteran piece of legislation that should not be ratified by this government. And that's my opening statement. Thank you.
Thanks a lot, Mr. Hulse. Now, Mr. Barry.
Yes, thank you, and good afternoon to everyone. Let me first acknowledge the military service of Senators McLaughlin and Lambie and any others present. To be honest, I've got to say I am more at ease discussing veterans or defence issues with fellow ex-combat Vietnam veterans. But here goes. Thank you for selecting me to participate and give evidence at this public hearing in relation to the Defence Amendment DHAAT Bill 2025 today. I am unsure exactly why I was selected. But anyhow, I sincerely hope you have a copy of my opening statement, plus a copy of my submission to Foreign Affairs, Defence and Trade, number 52, dated 25th of September 2025. I note there are 63 published submissions on Foreign Affairs and Trade website concerning this bill. I am unaware of those marked confidential. It seems all express very serious views about the proposed changes to the existing bill. I could only find one in favour, from Defence. Therefore, it is now most appropriate that all stakeholders get an opportunity to have a say. Initially, I thought these proposed amendments appeared to focus on simply reducing office administration rather than ensuring service is valued. Following more thorough research, I haven't changed my mind. Is it because of insufficient staff? Is it because, as in my dealings, there are no staff who endured infantry combat in Vietnam? Thus, no lived experience to fully comprehend the issues facing combat veterans and their recognition for being prepared to die in a foreign country at the behest of their government. We've all mentioned the award of the Victoria Cross for Australia to Edward Sheehan and Richard Norton, two excellent examples. These proposed amendments, if in place, would not have seen the Republic of Vietnam Cross of Gallantry with Palm Unit citation approved about 50 years after the war ended. It would also not have seen appropriate awards for valour to members who participated in the Long Tan battle some 42 years after the event. That former review affects some 50,000 Vietnam veterans. Then we have the Lockery versus Defence in 2022. A fresh interpretation of the eligibility criteria for the Republic of Vietnam Campaign Medal was announced some 50 years after the war ended. A new provision regarding wounded in action. I have voluntarily assisted 125 Vietnam veterans receive this medal in the last 12 months. There are 400 plus on my confidential list. Defence Honours and Awards has no record of how many of these medals have been awarded under the new interpretation. We have waited more than 2 years to secure a decision to recognise members and families of members of the Australian Defence Force who are injured, wounded or killed in as a result of service. Again, is this a staffing issue? Numbers of affected people are not known under this particular review. Since 1996, nearly 30 years, I've been advocating on behalf of 2,500 National Service Vietnam veterans and others from across the nation to be awarded the Republic of Vietnam Campaign Medal. In October 2023, the responsible minister decided to make a decision not to make a decision. He thought it was unlawful. There are 12 pages itemising strong supportive letters from former Prime Ministers, Deputy Prime Ministers, Governors-General, several ex-service organisations, retired senior Australian Defence Force personnel, and the Vietnamese veterans, the Rangers and the ARVN. Submission and letters sent to the Minister since October 2023, 2 years, from a notable senator, RSL New South Wales, and other strong advocates have all gone unanswered. Is this a staffing issue? I sent submissions in August 2025 to Defence Honours and Awards to have a small insignia attached to the Vietnam Medal ribbon, denoting those with multiple deployments, tours of Vietnam. Strongly supported by 2 former Governors-General, 2 former Prime Ministers, politicians from all sides, several ex-service organisations, a Victoria Cross for Australia recipient, many leading dignitaries and retired Australian Defence Force personnel. We estimate the affected number will not exceed 1,500. Defence simply said it did not plan to recognise multiple deployments despite other Australian personnel wearing the same devices on their ribbons for other conflicts. Is this another staff issue? I think this needs further investigation. Finally, I received confirmation last week that 184 names of World War I veterans have been discovered since 2013 and now will be added to the Roll of Honour at the Australian War Memorial. I maintain these previous unknown veterans would conceivably have descendants who may require a review of any honours or awards. This new bill would make any such reviews null and void. In conclusion, I ask that the responsible minister immediately withdraw this controversial Defence Amendment, DHAAT Bill 2025. Thank you.
All right, thanks, Mr. Barry. I know you mentioned earlier about why you have been called, and as my understanding from the Secretary, you placed a submission to this hearing. That's why we've called you to give oral evidence today. Now, I'll hand the call over to Senator Lambie to kick off with questions. Senator Lambie.
Thank you, Chair. I think I've heard that loud and clear. I'm not going to waste any more of the committee's time. So I'm in agreement with these gentlemen. So I have no questions for them. Thanks for showing up, gentlemen. Thanks for putting in your submissions.
Okay.
Sorry.
Mr. Holst, I can see you put your finger up there for a moment.
I'd just like to make a point of order, if I may.
Yeah, sure.
Thank you. I was asked to put an opening statement that would go for about 3 minutes, which I did.
Yeah.
That is not my address to the Senate. I have a separate address to the Senate, so I'd like to be given the opportunities to deliver that address in addition to my opening statement.
Great.
Yep.
That'd be great. Yeah, I'd rather you do that because in case I'm missing anything, that would be wonderful if you could do that for me.
Okay. And just in the interest of time, sir, how long do you think it might go for?
How long, George?
This would take me around 10 to 15 minutes.
Yeah, we don't normally allow it. Usually is very like a short statement. I'm just mindful that we have to get to senators with any other questions, but we can certainly table it as evidence and then we can circulate that. But I'm also happy for you for a few minutes to talk about the document if there was something there.
Well, I'd like to be able to talk about the document if I can't go through it, because I've got a challenging invitation at the end.
We don't normally allow witnesses to spend 10, 15 minutes on a statement like that, but we are allowed, I would be more than happy for you to talk about some of the areas you wanted to raise with us about the document for a few minutes.
Okay.
And then maybe we can come back with some questions. Is that all right, Senator Lambie or Senator Whittaker?
Yeah, no, that's great. Thank you.
All right.
Okay. Thank you very much.
It's all yours, George.
Yep, thank you.
The floor.
Well, I've already introduced myself and spoken about what I'm here to do. What I want to just expand on is that I mentioned that there were 8 applicants for whom I put in submissions, and of the 8, all of them were rejected. And during the time that Defence conducted its merits review, they never once contacted me nor any of my witnesses to include our reasons for a retrospective award to assist them in their deliberation when it came to the outcome of review. Not once, not ever. And yet Defence considered that they had conducted a merits review. So based on this thin excuse of a review, Defence rejected all 8 of the personnel for whom I was advocating a retrospective award. Let me just unpack that for a little bit. In the case of Private Richard Norton, Victoria Cross, he was a soldier when on the 14th of May 1968 conducted a one-man charge by fighting his way into a well-positioned enemy ambush where he was wounded by an enemy hand grenade, but continued his attack on the enemy, saving the life of one of his mates by dragging the critically wounded man out of the killing zone of the ambush and back to safety. Norton then attacked on his own for a second time into the enemy ambush while being shot at by a number of the enemy soldiers to try and rescue his other mate who was inside the killing zone of the ambush, but realising that his mate was dead, Norton returned to his section where he loaded himself up with ammunition and grenades and attacked for the 3rd time on his own, wounded, into an ambush and routed the enemy who abandoned their assault on Richard Norton's platoon. This was clearly Victoria Cross time. But no, the commanding officer of the 1st Battalion of the Royal Australian Regiment at the time, Lieutenant Colonel Philip Bennett, decided to award Norton the Distinguished Conduct Medal for his incredible courage and devotion to duty. Everyone was shocked at this decision, and it was amplified when the Governor of New South Wales, Sir Roden Cutler, himself a Victoria Cross awardee, having heard the citation describing Norton's action, was about to pin the DCM to his jacket, said the words, "What does one have to do nowadays to get the Victoria Cross?" Quite clearly, Bennett got it wrong. His recommendation of the DCM went up to the 1st Australian Task Force Commander, Brigadier Ron Hughes, and then from there to the Australian Forces Vietnam Commander, General Arthur MacDonald, both of whom supported Bennett's flawed judgment of the award of the DCM, and both of whom should have, returned the citation with a chance for Bennett to review his decision and instead nominate Norden for the VC. But they did not. They also got it wrong. In other words, 3 senior officers on the ground in 1968 were not infallible. They all got it wrong. Contemporary defence perpetuated the mistake, and then a modern-day 3-star general also got it wrong by rejecting Norden for the Victoria Cross because he found that there was no maladministration nor compelling new evidence supporting my claim for Norden to be awarded the VC for Australia. And this is the point of my example. Had it not been for the existence of the tribunal and its ability to hear the arguments put forward by an advocate such as myself, this account of a selfless act by a brave Australian soldier would never have seen the light of day. I thank God for the existence of the tribunal and its current capability to hear cases such as I've just described. It is the quintessential embodiment of the famous Australian axiom, a fair go. But if this bill passes by this Parliament, the tribunal will have its ability to hear accounts such as those of Norden severely truncated to a 20-year envelope commencing when an Australian operation is terminated. This is a regressive step for the Albanese government. This government claims to be a progressive government. This regressive, constraining and restrictive bill describes a government that is opposite to a progressive. It is regressive. It was the defence team that put the minister up to this, not the tribunal. I wrote a letter to Mr Keogh explaining that fact by providing him with extracts of the Senate review. And that letter is attached to this document which I intend to table. So for those who want to hear more about what happened during the battle in which Private Richard Norden was awarded the Victoria Cross, I want to give you an opportunity to learn something that is absolutely unique. This is truly a one-time opportunity. It won't be repeated. And it's this. I challenge you to come to the tribunal hearing being held tomorrow morning, commencing at 10 a.m. in the Ridges Hotel in Canberra Avenue, Forest, and hear at first hand what it was like when the mortar platoon of the 1st Battalion of the Royal Australian Regiment was overrun by the enemy soldiers during the Vietnam War. Within minutes of the commencement of this enemy human wave attack, this Australian platoon was wiped out. A few of them miraculously survived and are able to tell their account of what happened and the appalling lack of recognition they received after the event. After hearing what they have to say, come on back into this place and go ahead and vote with your conscience, if you have the courage to do that. Because if you pass this bill into law, you will forever silence the voices of veterans such as those that you will hear at the tribunal hearing tomorrow. I'll be there to welcome you. If you can't make it, please send your senior advisor to listen on your behalf. This is a veteran's challenge to you to hear some unpleasant truths about the Australian Defence Honours and Awards system. I plead with you to keep the tribunal alive within the current rules as they exist in this, the land of the fair go. I appeal to everyone in this House to reject the Defence Amendment DHAAT Bill 2025 as a regressive, restraining and reprehensible piece of legislation designed to silence the Australian veteran. Thank you very much for listening. And that's a document I'd like to table.
Table? No worries. We can certainly do that. Thanks a lot for that, Hulse. Thank you. Now, Senator Lambie, did you have anything following from Mr Hulse's contribution you'd like to ask?
No, I do not. Thank you so much. Thank you very much, gentlemen, for attending. That's very good of you.
All right. Senator Whittaker, did you have anything from your end?
Just a couple of questions. Thank you, Chair. And thank you very much for those opening statements and comments, both Mr Hulse and Mr Barry. I've just, I guess, got some specific questions if we can go to some of the specific aspects of the bill. And while I note that you've said, I think you've both said that you think that the bill just shouldn't proceed at all, but I hope you might humour me for a minute and just talk through some of the specific elements and whether there's, I guess, a kind of way forward on some of those specific measures. So first to the 20-year time frame limitation on making an application for review to the tribunal. Is there a time frame that you think would be more appropriate than 20 years?
Who's that referring to?
Sorry, that's a question that I'd love to hear both of your responses to.
Okay. So, sorry, I didn't get your name.
I'm Senator Ellie Whittaker from Western Australia.
Okay, thank you, Senator. Look, quite simply, the existing legislation, I think, you might just correct me, goes back to 1939. Is that correct?
That's correct.
Why change it?
I guess these are the questions we're asking today. That's been proposed by the government.
But what's the reason? What's the reason? It better be a good one, I suppose, because the veteran community are up in arms. What's the reason for changing it from 1939?
Well, perhaps I could put to you, my understanding is that certainly one of the reasons is about the challenges that come from gathering evidence for a case that happened so far back in the past. And so in terms of making decisions that are based in fact and evidence, that might become more challenging as time goes by. Now, I'm not, that's not my opinion. That's the basis on which the bill's been put forward. I think the Minister talks to it in his second reading speech. So I guess I'll put that question to you. Do you accept that there are challenges with going back to 1939?
My answer to that would be these blokes and ladies, they were sent overseas, right? And a lot didn't come back. Surely we consider each case on its merits. Why put a carte blanche thing right across the board to eliminate everybody? I just can't see the reasoning.
Thank you.
So can I answer the question?
Do you want to add anything there?
Yep.
Please do, Mr. Holt.
Yep. Senator, I've just unpacked a classic example of something that happened in Vietnam, and it's quite clear that the senior officers in those days got it wrong. I've also unpacked a situation where it's quite clear, and we have evidence and witnesses to support it, where one soldier, Richard Norden, was awarded the Victoria Cross. Now, that goes back far enough, 50-odd years, to show that Defence's argument about a 20-year memory span is false on two grounds. First of all, we can go back more than 50 years and talk about something quite clearly and support it with evidence, documented as well as witness evidence. So that blows one of their arguments out of the water. And the second thing is that they think that the senior commanders are infallible, and they're not. I've demonstrated that right up to a 3-star general who was in the seat before General Simon Stewart took over the job. So their argument is flawed on both accounts that I've just put forward. Now, you asked the question about how far back we should go. Well, I think it should be left alone at the 3rd of September 1939 because there's been recent cases where we had reports from a Japanese fighter pilot who shot down a Royal Australian Air Force aeroplane, and those Royal Australian Air Force service members received an award for their courage and bravery while that was going on. That goes back to the Second World War, and it was quite clearly enunciated, and the witness statements provided. So that again shows that there's a flaw in the logic behind Defence's reasoning for a 20-year gap. I don't believe it. I'd like to. Another example. Yeah, I'd like to just put it to you this way. The system is not perfect as it is right now. We all know it. But this is not the way to go about fixing it. The way to go about fixing it is to do a bottom-up, top-down review across the board. And you bring in defence, you bring in the tribunal, you bring in the stakeholders such as myself and witnesses and other people, and you say, where do we go to from here? And if we're going to have a progressive government, why don't we split the system so that we have individual accounts where we can go back to the 3rd of September 1939, but where we have unit accounts for such decorations as a meritorious unit citation, we go back to 1901 so that we can go right back to those units that are on the board today, and we've got them on the board today that landed at Gallipoli, first boots to hit the sand. And we write all those people out of history because we put these timelines down where we think that that's as far back as we should go. So I think it's time we took a whole new look at this whole the Defence Honours and Awards space and rebuilt it, because it's not fit for service. And this bill demonstrates that there's a problem with it, and if this bill is passed, it's going to exacerbate this not fit for service capability that we've got in the Defence Honours and Awards space. Thanks for the opportunity to say my piece.
Okay.
Thank
Senator Whittaker, do
you.
you have anything else? No?
Thank you very much. Mr. Hulse, no.
Okay. Thank you very much, gentlemen. Really appreciate the time today, and we'll table all those documents.
Sorry,
Yeah, thank you.
As well, too.
I didn't get your name, Chair. I apologise.
Senator Ciccone.
Okay, thank you very much.
Good on you. All right, gentlemen, well, thank you very much and appreciate the time today. Now, we're going to suspend briefly and get ready for our next lot of witnesses. Thanks, everyone.
Okay, all
Thank
the
you.
best yourself.
Thank you. Have a good one.
Bye-bye.
Good one.
I now would like to welcome representatives from Veterans Emergency Services and Police Industry Institute of Australia, Legacy Australia, and the Australian Peacekeeper and Peacemaker Veterans Association. Now, for the Hansard record, could I just ask everyone to please to state your full names and the capacity in which you appear today? We'll start with Veterans Emergency Service and Police Industry Institute of Australia.
Good morning and good afternoon, everyone. Thank you for having me. My name is Helen Hennessy. I'm the CEO and founder of VESPIA, or the Veterans Emergency Service Police Industry Institute Australia.
Thanks for that, Mr. Hennessy. Now, Legacy Australia.
Thank you, Mr. Chairman. I'm Legatee Mark Roger-Lax. I'm the Vice Chairman of Legacy Australia, and it's in that capacity that I appear before you today.
Excellent. Thank you, Mr. Lax, Dr. Lax. Now, Australian Peacekeeper Peacemakers Veterans Association. Who do we have?
You've got Ian Lindgren, Senator. I'm the immediate past chairperson of the Australian Peacekeeper and Peacemaker Veterans Association and the current advisor to the board.
All right, and I understand Mr. Copeland's on his way in.
And Mr. Copeland, he's currently in Perth. He may or may not make it. The Veterans Review Board, I understand, is becoming a very complex issue today, and he gives his serious apologies if he does not make it.
That's okay. We'll note that. That's fine. Now, did any of you have an opening statement? And if you did, if we're able to table them, we'll go straight to questions from senators, unless there was anything that you'd like to flesh out of your opening statement for about a minute.
Mr. Chair, if I may.
Dr. Lax, yep.
I'm happy to table my opening statement. The Secretariat received that, but I do wish to make it known to the senators that I have a disclosure to make. I was on the inaugural tribunal when it was formed under the Rudd Government 1, and then transitioned to the DHAAT in 2011 under the Gillard Government. So I'm quite familiar with the processes. That completed in June 2015, and I have not had any other involvement with the tribunal.
I appreciate that. Thank you. Mr. Lindgren, did you put your hand up before?
I did, Mr. Chair, if it's okay.
Yeah. Sure.
On behalf of the Australian Peacekeeper and Peacemaker Veterans Association, I do wish to advise you, Chair, that, and the committee, that today I speak with the strongest respect for you, the committee, and I wish to say that what I'm about to say could be understood to be considered inflammatory, but I wish to assure you that it's not at all. Our intent is not to criticise or to contribute in any way but constructively, transparently, and utilising all the elements of good governance, transparency, and to assist the Commonwealth to achieve what the Royal Commission asked, and that was to demonstrate that a veteran's life matters. We oppose this bill in the strongest possible terms. And I won't talk about the technicalities that most of my colleagues will have talked about today. Had Paul Copeland been here, he would have, because that's his area of expertise. What I'll talk about instead, very briefly, in this opening statement, is governance, transparency, something that we don't often discuss. And the question I'd like to ask is, why are we here? And I say again, I don't mean any offence by this, but the Senate, for the benefit of many people that are watching and don't understand government process, the Senate, of course, holds the government, which sits in the House, to account through these types of activities. And when the Senate makes recommendations and holds meetings such as this, the accountability falls back to the House of Representatives, which of course has got no powers to enforce anything that was recommended. Therefore, all the recommendations that have been made, as far as we can ascertain, fall back on public opinion and media mechanisms to hold the government to account. This brings me back to the question, why are we here? Now, the House of Representatives hasn't, as far as I can tell, provided you with the terms of reference. If you don't have a terms of reference, then what are our reporting objectives? How can we assess apples against apples? I guess we're lucky today that most of all of the veteran community is addressing one thing in one way, from what I can see. But this trend for veteran activities is getting increasingly regular without terms of reference being provided from the House to the Senate. And when you consider the last time that I appeared here, and I did appear for myself, not the association, but we were discussing the Defence and Veteran Services Commissioner, there is nothing, if what I've said was true, if what we've said is true, there is nothing holding the Commonwealth to account to establish a Defence and Veteran Services Commission standalone act, and there is nothing to ensure that families and all the other recommendations that were made will actually happen. And that's very, very concerning. If we look at the recommendations from the Royal Commission into Defence and Veteran Suicide, some of the key personnel-related issues were that we were to stop taking anything but a trauma-informed practice to veterans. And yet, if we look at this bill, the previous bill that I mentioned a few moments ago, these things have just turned up. The submission Schedule 9 to which established the Defence and Veteran Services Commission. I mean, it wasn't just a schedule; it was a bill, and it turned up in the Senate. I don't think that's particularly common when it's more than just a note to a bill, when in fact it was actually really should have been established as a bill itself. If we look at the readings within the House of Representatives, being the first reading, the second reading, the explanatory memorandum, and you look at it from not just a government business process point of view, but you look at it from a business point of view, there's no cost-benefit analysis, no root cause analysis. There's a statement in there that says any additional costs will be absorbed by the government, yet if we cull half the people, there won't be any additional costs because they will be culled. So the explanation that these things are complex is particularly perplexing, and we don't understand how we've got this far and how we continue to have these very short notice timeframes for which all these people here today have had to prepare, because I've spoken to most of them, and the time frame is considered extraordinarily small. And at that, I'll leave it because the questions are the most important. Thank you, Chair.
And just very quickly, I just want to see, Mrs. did you have anything you'd like to add before we go to questions?
No, I'm happy to table my opening. Thank you.
Okay, thank you very much. All right, we'll go to questions. Now, Senator Lambie, are you there?
I am here. I am, yes. I only have one or two questions, so I'll be very quick to get round the rest of the panel. Mr. Lindgren, I can't tell you why you're here because I have no idea. That's why I thought you were sitting here. I thought you might be able to answer that question for me. Obviously not. Mr. Lindgren, can you tell me, you've put in there, APPVA has, and I know that Paul's not here at the moment. Can you describe this conditions of service review panel a little bit more for me? Is that something coming from you or Mr. Copeland?
Mr. Copeland's actually just come on the screen.
Oh, there you go. Okay. Well, Mr. Copeland can he hear me? Paul, could you explain? G'day, mate. Can you explain the conditions of service review panel? What does that look like?
Sorry, I'll just pop onto this. So my apologies for running late. I was at a VRB, but the concept of a...
It's before you do that, Mr. Copeland, can you just, I just ask you, before you start, for the purpose of Hansard, just state your full name and the capacity in which you appear today, please.
Thank you, Senator. My name is Paul Arthur Copeland. I'm the Director of Current Issues for the Australian Peacekeeper and Peacemaker Veterans Association.
Thank you. All right, anyway, please proceed with answering Senator Lambie's question.
Senator, the concept of this review panel, and I'm assuming you're talking about conditions of service.
I am, Mr. Copeland. Yeah, that'd be great. Just explain that so I can put that in my head, mate. Sorry.
Yep. So it comes as a result of numerous attempts by veterans over a considerable amount of time, at least 18 years, to have their service reclassified because they were what they would term as being caught in the middle of a war zone, for example, Beirut, where buildings were disappearing around a particular unarmed UN military observer. And the Department of Defence has, in particular the Director General of Nature of Service Branch, has continually and consistently refuted his quest to have his service reclassified. Now, to have that decision reviewed by the Director of Nature of Service Branch, it actually has been requested, but they won't do it because it's like somebody marking their own homework, for example, with the reasons that they've given, and they really haven't given any factual or legal reason for it. They've mainly just refuted it based on a 10-year review that was authored by one of their officers who we met in Parliament, who was quite, unhelpful in listening to the point of view from the veteran in per se. So the reason for this is because there is a grievance, and within Australian administrative law, the next step for this veteran to go to is actually the federal court, which is realistically, morally and cost prohibitive. So therefore, whilst we have a mechanism there for defence honours and awards, which is obviously a very, it can be an emotive issue, but it's also based on people being appropriately recognised, we have a situation where determinations of service by the Minister and decisions made by Defence in seeking that change are basically being refuted without any sort of merit review.
And that is what you were hoping for this review panel that will do. So you want that in service before you want that in service, the review panel.
Yeah, well, basically, most of the...
How do I make them, Mr. Copeland, as you would know, how do I make them independent from each other either way? How do I do it?
Okay, well, I may say that in defence of the DHAAT, I think they've been reasonably independent, but they have suffered, I believe, the influence from Defence, and that is the case while we're sitting here at the moment, is that there is a Defence appearing to trying to own what has always been intended to, from the very beginning, an independent and impartial merits review tribunal, which is questionable at best. But if I may say, the same sort of thing needs to go in for conditions of service, because there are stacking up claims and retrospective service that is now being realistically ignored. Rifle Company Butterworth haven't realistically had their day in court or an opportunity to present their merits to a merit-based review tribunal. And that is the same for unarmed peacekeepers who have served in the middle of a war zone that were at great peril to themselves, and the government doesn't seem to see that as war service. So that is the reason why we've sort of put up this point about the quasi-judicial setting for reviewing conditions of service decisions, particularly determinations from the Minister.
Okay, thank you. Thank you so much for that. Thank you, Chair. I have no further questions.
Okay, I'll go to Senator Shoebridge and then Senator Collins.
Oh, thanks, Chair. And thanks very much for everyone's submissions. And, you know, across the board, the veterans community is, I think a polite word would be, engaged with this bill. Could I just deal quickly, and I'll put it to any of you, the 20-year time frame. I'm sure you've read Defence's submission. Defence are justifying that 20-year time limit by reference to some reports that I think the Tribunal did in 2017, where they said, as at 2017, it was actually getting really hard to find contemporary evidence in relation to World War II. And they thought at some point there should be a line drawn for reviews for World War II, and were contemplating, I think they eventually said September 2020 might be, 3rd of September 2020 might be an appropriate time to draw a line for applications for World War II. Now, my math says that's 75 years after the war concluded, where the Tribunal, having looked at a bunch of cases, said that, well, once you get to 75 years, it's pretty hard to find compelling contemporaneous evidence. And, you know, maybe there's an argument for drawing the line at 75 years. But for the life of me, I can't find how you then, out of that, come up with this bill, which says 20 years and a 20-year limit. Does anyone want to reflect on maybe whether or not that 75-year limit might be something to look at, and otherwise on the 20? I'll go to you, Dr. Lax first, and then Mr. Copeland.
Thanks, Senator. Yes, Legacy is concerned about this. I've declared before that I was a member of the Tribunal, so I'm aware of its complete background. The 3 September 1939 date was chosen after discussions with Government Defence and DVA, but that's gone now. That's quite a long way back. Now, if the 20-year at the end of an operation rule comes in, can I just suggest that anybody that served on the following operations, first 5 are Timor, the second one is Iraq, one's Bougainville and Afghanistan, will not be eligible for review.
East Timor.
That is Op Spitfire, Op Warden, Op Stabilise, Op Tanager and Op Citadel, all of which lapsed on or before 2003. Op Falconer, the actual warfighting component of Iraq, lapsed in 2003. Op Belize, which was the peacekeeping operations in Bougainville, which was under, well, some people would say warlike conditions, but others wouldn't, lapsed in 2003. Op Pallet, Afghanistan, lapsed in 2004. And 2 others, Op Quickstep, which was the stabilisation of Fiji, and Op Paladin, the UN peacekeeping operation in the Middle East, both will lapse next year. So if this is enacted, anybody that served in those campaigns, if they haven't already got their medals, would find it extremely difficult to put in a review to get their just reward. So I will leave it at that, but essentially that just puts into perspective that this is definitely living memory. It's not Gulf War, it's not Second World War, it's not Korea or Vietnam. It's quite contemporary, and I think that's really important that the Parliament recognises that. Thank you, Senator.
Thanks, Dr. Lax. Mr. Copeland.
Thank you, Senator, and I concur and support what Mark has actually stated. Absolutely correct. And from a peacekeeper's perspective, I mean, peacekeeping operations have been going since 1947 to the present day, and we continue to do that. We are one of the few nations in the world that have actually continuously contributed non-stop to these operations. So that does leave a dilemma for a range of those operations. There are other ones that people are talking about seeking through our working group, of course, for the Mururoa Atoll French testing, the French nuclear testing, when they supported the New Zealand Navy in 1973. There are many other humanitarian aid and disaster relief operations that have yet to be not only recognised by the Prime Minister and Cabinet, medal section, but they seem to refute a lot of the submissions that have been put forward by defence in any case for those retrospective operations. For example, the operation that was up in PNG when that tsunami hit, those men, despite the recommendations from then Major General Cosgrove at that time, those men and women haven't been recognised, and that is a travesty in its own.
Well, I mean, I see Ian's had put his hand up, and Shannon, feel free to if you have a contribution as well. But what about the idea of, I think the tribunal was thinking, about a 75-year time limit, because by then there really isn't contemporaneous, fresh, living memory. Would there be the same agitation about a 75-year limit? Maybe there's some sense in having some kind of backstop.
Senator, I don't think that there'd be a concern if there was a believable backstop, one that could be enacted and couldn't be ignored. And I know that sounds cynical, and I don't mean it to be, but we've got a case now, and I'm not mentioning any names, but I did supply a number of you with documents about it. 1993, the Chief of the General Staff issues a directive for someone to be employed in a role, and he's pictured in Australian uniform, in Caballo, and in many other peacekeeping and warlike environments between then and 1996, and yet he wasn't. The Chief of the Army equivalent, his words are not true. And they've not been taken as being the basis for an employment contract, because the documentation was written on paper, and it is, even the Director General of the National Archives of Australia and his key team that I've spoken with cannot find it, and cannot find it with Defence. Yet Defence can find a document that says the Chief of the General Staff perhaps isn't telling the truth from 1993. These are the issues that still keep these things alive and are worthy of debate, because they need to be. That particular person and many others like him, men and women, certainly have existing situations today.
Shannon? Oh, Ms. Hennessy, sorry.
Shannon's fine. Yeah, look, I absolutely, thank you. Absolutely in agreement with the rest of the panel here. I think, from my perspective, having a time limit seems a little bit arbitrary, especially when it would be interesting to know how many requests are being made that are post the 75-year gap, and what the requirements are, or what the pinch points are to realistically enable these honours to be put through. I think we have seen, and we sort of spoke to in our submission, that from a historical point, what if we do find documents 60 years from now and it's past the time limit? That shouldn't then prohibit or prevent someone who did a heroic act in service of the nation to be denied their honours just because, well, the time limit's passed, so bad luck. Though there shouldn't be a time limit on recognising that the service of our men and women across any.
And I haven't heard from the tribunal that they're being flooded with a fresh raft of World War II applications. But as you point out, if fresh evidence did become available, maybe from another nation's archives or from some other source, I mean, why should there be an arbitrary time limit?
Yeah, I think that's exactly our thought process, and that as Max sort of noted, what warfare looks like now and what that's going to look like 75 years from now. Are we going to have access to the same documents? Are we still going to be running into these same things? If we put these time limits in place now, what are the repercussions of that down the line, especially for contemporary soldiers who have served in Afghanistan and Iraq, and over the last 20 years, with a 20-year time limit, even from the beginning of Afghanistan to we're now 25 years past. So we start to, I think, run into these issues of we've already run out time limits on things, and we do, as Ian noted in his opening statement, we do need to consider the mental health of both the service member and family. Honours are an emotional thing. I think we can all agree to that. So when we start to put that pressure of timelines, and what if we do find Grandpa's secret box of documents in the cupboard 20 years from now, and that time limit's run out and we can't recognise the work that was done, how devastating is that going to be for the family that wow, we finally found it and now it's gone? So we would certainly argue against those time limits, and while 75 years obviously does push that out, again, I think it kind of kicks the can down the road.
Because I'm running out of time, some of these issues also relate to the 6-month review period, because you may find fresh evidence 20 years down the track. You may open that shoebox, you may have that document found 20, 30, 40 years down the track. It also applies to that 6-month timeframe in which to seek a reviewable decision, doesn't it? Much of the same thinking. But I'll go to you, Mr. Copeland.
Thanks, Senator. Look, I support what Shannon is saying, and I think everyone's in agreement there. But the other case is that I've got to highlight that the Australian War Memorial became a witness to the Defence Honours and Awards inquiry that we had that was heard late in the afternoon, I suggest, on the 7th of February, when they actually commented, I think it was Matt Anderson, the director, commented that they received a lot of inquiries about honours and awards, and it goes back to World War II at least. So I think that sort of places a bit of a justification with that problem.
Yes.
All right.
Mark.
We might move a call around. And
I think Mark, did you have one final comment?
If I may, Senator, please. Just an example of this is the quite recent award of the VC to Seaman Teddy Sheehan. It was the nephew that pushed this case, not a close family member, which relates to another one of those conditions on this draft amendment. But it took certainly more than 6 months for them to get their information together and seek new evidence, which in fact they did. So this is just one example of what might happen in the future should this legislation go through unchanged. So we, in terms of legacy in regards to the family, it talks about immediate family member, and it's very specific. It actually lists who they would consider to be immediately family members. But nephews, aunts, uncles, nieces, grandchildren and so forth are not considered. Yet with time passing, they're the more likely to be the ones to discover that their loved one has not been given their just desert. So I just put that on the table for you to consider. Thank you, Senator.
I'm mystified as to how you would rule out grandchildren, given what we know. And your point here about nephew, I mean, I think it's a compelling point. Thank you, Chair.
Thank you. All right, thanks. Now, Senator Collins, I'll come to you.
My questions are for Dr. Lax. Your submission states that you do not believe any meaningful consultation took place between ex-service organisations and Defence or the Minister's office. You also note that the Minister briefly mentioned potential changes at the ex-service organisation roundtable meeting on the 27th of August in 2024, but that you only became aware of the bill when it was introduced and debated in the House of Representatives earlier this month. So did you interpret the Minister's comments at ESORT or the roundtable as sufficient notice that such significant changes would be introduced without further consultation with the sector?
Thanks, Senator. I wasn't actually at the ESORT meeting. I'm not party to that roundtable. As far as legacy was concerned, it came to us as a surprise. So the system either broke down, we were aware of the Minister's speech to Parliament in August, and that sort of prompted us to start thinking about this. But other than that, I cannot confirm or deny either way that whether we received enough information in the past. Thank you.
Okay, thank you. And are you aware that the Department of Veterans Affairs considered the Minister's comments at the roundtable so inconsequential that they were not even recorded in the official meeting minutes? I understand that you weren't there, but it's just a...
Yeah, I can't comment on that because I wasn't there.
Sure. You recommend that the Senate not support this bill. In your view, is there anything of value within the bill? Or are there any genuine issues with the tribunal that need addressing? Or should we just reject the bill in the Senate as it stands?
No, I think the fact that we're going through this process now is very, very appropriate. Certainly, I'm sure you've been hammered by various ESOs and the submissions you've received about why they think this is inappropriate. But certainly there are a number of issues that should be taken forward. The 100-year rule age limit for length of service awards being one of them, for example, which is tied into the 20-year clauses in the draft. And the other thing is who can apply for the tribunal for review. The note to the business about the immediate family actually states that the tribunal, under exceptional circumstances, can take review requests from those that aren't considered immediate family members. So that's a good inclusion because it may pick up the nephews and so forth. But it's not exactly clear at how far out the tribunal could make that decision. The other thing too is I note that inquiries and reviews are quite separate. The tribunal conducts both. Reviews are basically cases on merit brought forward by members and their families. Inquiries are usually agreed by government and directed by government. And those generally don't have that fixed time limit, whether it's 20 years, 1939 or whatever. In fact, the ones that I did when I was on the tribunal went back to World War I, and I think that would still apply. So that is worthy of retaining. The fact that the government, for whatever reason, can direct the tribunal to conduct an inquiry into a case or cases, such as the one that was mentioned about the Rifle Company Butterworth, that being one, although that actually has been dealt with. But certainly that side of the legislation is appropriate, and I don't think they should change the direction to the tribunal, the fact that they can take both reviews and inquiries. Thank you, Senator.
Okay, thank you, Dr. Lax. Chair, just one final question, and for Mrs. Hennessy this time. I'd just like to get your views on that as well. Your submission closely aligns with that of the Coalition's perspective on this particular bill, and you've suggested amendments to improve it, but given the extent of the issues in this particular bill, would you recommend to withdraw it entirely? Or is there any value in proceeding with the bill and trying to get amendments through?
Senator, thank you. To be perfectly honest, at this time, I would prefer to see it rejected and you retabled and we go through the process a little bit better. So your point about it being raised to ex-service organisations at the ESORT, that your ESORT is quite a hot topic among the community anyway, but is quite limited in who attends. So, for instance, my organisation, as well as dozens here in Western Australia, are not privy to those meetings. It is an invite-only situation. So to have that be the only place where a minister would announce a review into significant legislation like this simply isn't good enough. That's not engagement with the broader community. Our institute represents over 100 individuals and organisations, and obviously we weren't even aware. We found out about this through a LinkedIn post from someone else. So that's sort of the filtration of information about these amendments. So that consultation is really important to the community. Wherever legislative change happens, the veteran community is really very invested across everything that happens, and I don't think making any significant change to a legislation without comprehensive consultation and engagement is appropriate anyway. Certainly a submission echoes a lot of the same things with the gentleman here today. I'd like to just sort of propose a bit of a personal anecdote around the immediate family member issue, in that my husband is active service. He serves here in Perth. We will not be having children due to personal medical reasons. So should my husband pass away and I either predecease or pass after him, there is no, under the current guidelines, immediate family to put in a submission on his behalf. It would be left to our nephews to do so. We need to look at what contemporary defence families look like as well for the future of this legislation. I think there is a lot of focus on past conflict and looking to World War II and looking at appeals there, but this legislation will affect into the future. So being very conscious of what warfare will look like and how we're going to manage that in the coming years with what's in the pipeline anyway, but looking at what defence families are going to look like 20 years from now is going to be significantly different to what we're used to. So I think there's just too many questions being raised and too many pieces. We wrote quite extensively around the right to appeal cancelled medals and spoke to some of the issues that were first, the West was facing here following the RG-ADF and the Brereton report. So I think a few steps have been missed on this particular piece of legislation. It's not to say that there shouldn't be review. Legislation should always be reviewed. I'm in full support of that. However, where it pertains to especially things like awards and honours, I don't think there can be time limits around when people receive recognition. And the more we restrict that, just sort of speaks to the fact that do we really want to recognise people for their work in the meantime? Is that really a genuine effort if we're putting all of these stopgaps around it? So certainly I would recommend that this go back to the table and receive actual consultation and engagement and review before anything gets passed, because once it's through, changing it back, that it's unlikely, but certainly even more difficult.
Okay.
Thank you so much, Mrs. Henderson.
Now, we need to move along. Are there any other senators that had any other questions?
I've just got a couple, if that's all right, Chair.
Yes, sorry, David. Off you go, mate. Sorry about that.
No problem at all. Mr. Lindgren, we've heard from everyone that the bill should be withdrawn. I'm interested is this an issue that you hear from members about, issues with the tribunal, and is there something to look at here?
Senator, yes, this is an issue we hear across the whole spectrum of the defence and veteran ecosystem, which is a phrase many people throw around, but few people understand. And in this particular case, if I boil it down to this bill, going back to basics and understanding why things happen below the top level where the ministers see things and understand what good quality mechanisms are at the base and that have been in place for 20 or 30 years or 40 years or 50 years and could now be improved is something very, very significant. And I think Shannon may or may not agree, but I mean, from the ESORT's perspective last year, our organisation was the only organisation, and I'm not having a shot at anyone else, but we canvassed and held monthly meetings so that we could get this input and this information from organisations such as Vespia. So it is widespread that we just don't see the underlying issues addressed first. It's just what's visible at the top, and it's not really going to make a change.
Thank you. Maybe just finally, I know we're running up on time. Ms. Hennessy, you've also told us that the bill should be rejected and that you feel more consultation is needed. We've got the department coming up. How can they have not only more but broader consultation? What does that actually look like? I'm guessing it's more than just dropping it into an ESORT meeting as a topic of discussion. What would you like to see happen?
It is, I think...
Sorry, this is from Ms. Hennessy.
Sorry.
Apologies.
Dropping into ESORT is one point, one port of call, I guess, when it comes to consultation. We have seen consultation done en masse over the last 12 months from the department in regards to the wellbeing agency that's being raised, as well as the discussion around peak body, which we understand and we're in support of that consultation continuing through co-design groups and online sessions and things like that. There's so many ways to engage with the ESO community, especially that the ESORT that happens in Canberra is not the only ESO roundtable that happens around the country. While that maybe looks more at a national perspective, it is certainly only a snapshot of what's happening. Here in the West, we have our own ESORT that is run by our reserve unit, the 13th Brigade, which has been very successful. It meets quarterly. I'm aware that similar things are happening in far north Queensland and in New South Wales and South Australia. So these points of engagement exist, but it's absolutely part of the department's work, I guess, to reach into those groups and to reach out to organisations like Vespia, which we are set up as a professional body to help enact this work as well, where we're more than willing and prepared to host consultation sessions and to filter out information and be a connector in this space. So, I think it's dropping into one ESORT is a drop in the bucket. It's a good start. There are some wonderful organisations that are a part of that, but that consultation must take more than one format. It must reach these professionals where they are, whether that's through online consultation, even a survey or something. And as Ian alluded to in his opening statement, even a terms of reference from the Senate, so that we know what the outcome is. I think the veterans community is very much an outcome-driven group of people that when we know what you want us to do, it's much easier to do than just saying, oh, we're making changes and I guess you can have a say on that. It's not unheard of. It's not new for the department to do stakeholder engagement on large-scale issues. And in comparison, this bill is you're likely much smaller in its need for consultation. We're not talking about raising a whole new agency here. We're just talking about some of the pieces of existing legislation. So, certainly agree that more can be done and the precedent exists to do so.
Thank you very much. Thank you, Chair.
All right, thanks a lot for that. Now, we do need to move along because we've got the department with us. On that note, just kind of say thank you very much to all the witnesses who have appeared this afternoon. We'll just take a very short break and get ready with the department. Thank you, everyone.
Thank you.
Thank you, sir.
Thanks. Maybe running about 5 to 10 minutes behind schedule.
Yeah, just seeking a sound check before we commence.
All good from my end, Rear Admiral.
Thank you.
Loud and clear. All right, well, welcome back, everyone. I'd now like to welcome representatives from the Department of Defence. I understand that information on parliamentary privilege and the protection of witnesses given evidence to Senate committees has been provided to you. Now, could I just ask for the Hansard record, if you would just state your full names, the capacity in which you appear today?
Yes, good afternoon, Chair. My name is Rear Admiral Richard Bolton and I'm the Deputy Chief of Personnel.
Good afternoon, Chair. My name's Patrina Cole and I'm the Assistant Secretary of Work Health and Safety.
Excellent. Well, thank you. Now, did you have an opening statement? Because we can just table that.
Chair, if you'd oblige me for a very short opening statement. We have been listening to some of the earlier testimonials today. I'll keep it short because I understand.
Please just keep it brief. Yep. Thank you.
Yep. Everyone that's dialed in today would be aware that the Defence Force places a high priority on the importance of recognising the service and the sacrifice of its members. We do this through a structured system of Defence Honours, Operational Service Awards and Length of Service Awards, and there's a distinction between all of those categories. These honours and awards are not merely symbolic, they are formal, and an enduring acknowledgement of individual and collective contributions to our national security. The integrity of the process by which these awards are assessed and granted is something we take extremely seriously. Since 2011, Defence has announced an average 140 honours awards annually. In 2024, we processed 17,700 applications, resulting in the award of more than 37,700 medals, class citations and badges. Independent of Defence sits the Defence Honours and Awards Tribunal. It is the only body of its kind in the Commonwealth and contributes to Australia's proud tradition of administrative review. The Tribunal reviews around 4% of Defence honours and 0.09% of Defence award determinations. In its submission, the Tribunal notes that they affirm or support 59% of Defence decisions that go before them and set aside, that is, not agree with 14% of those decisions. We believe these figures speak to the robustness and fairness of the Defence process. There's several key issues that this bill seeks to address, and many of these have come up this morning. First is the challenge of historical evidence. In 2017, the Defence Honours and Awards Appeals Tribunal released a report into the inquiry into recognition for Far East prisoners of war who were killed while escaping or following capture. The report recommended that consideration be given to adopting an appropriate limitation period with respect to subsequent conflicts. The Tribunal's recommendation reflects Defence's own experience of significant challenges in sourcing evidence for historic cases, which will only increase with time. A second issue is that applications made to the Tribunal without the knowledge or consent of the affected person or their family can cause distress and confusion. That someone with no relationship to an individual can initiate a review lacks fairness and sensitivity. An example of this has occurred following a hearing where an applicant who was neither related to the families nor a witness to the actions, nor in the chain of command, sought medallic recognition for a group of individuals. The families involved had not given consent and the lack of supporting evidence is problematic. The outcome did not meet the applicant's expectations and unfortunately it caused anxiety and distress among the families. Defence supports the intent to place families at the centre of the review process by requiring their consent. This is about respect, dignity and ensuring that recognition is not pursued in a way that inadvertently causes harm. A third issue is Defence's long-held position that self-nominations for honours awards lacks objectivity. Defence has been advised by the Tribunal that it is obligated to accept applications for Defence honours from affected persons, as the current legislation allows the Tribunal to review all applications, including self-nominations. Defence believes an affected person cannot reasonably assess their own actions for bravery in the context of a collective operational effort. Eyewitnesses and those in the chain of command at any rank are best placed to evaluate conduct. While most applications come from these sources, approximately 40% of the Tribunal applications are self-nominations. This is inconsistent with practices in other Commonwealth nations. Defence supports the bill's exclusion of self-nominations from reviewable decisions. In conclusion, Australia operated under the Imperial Defence Honours and Awards system until 1975, and then both the Australian and Imperial systems operated in parallel until October 1992. Defence Honours and Awards under the Imperial system had their own distinct eligibility criteria and quotas. The Tribunal is currently assessing Imperial awards against the contemporary Australian system, which we're of the view is complex and difficult to align. Thank you for the opportunity to open.
All right, thanks a lot for that. Just mindful of time, but we'll crack on with questions. Now, I'll start off with Senator Collins. You're just on mute there, mate. Thanks, Senator.
Thank you.
All right.
Can I please just confirm that Defence, can I confirm whether it was Defence was responsible for drafting the Defence Amendment, Defence Honours and Awards Appeals Tribunal Bill?
Thank you, Senator. Defence certainly drafted the bill in consultation with government, yes.
Okay, thank you. And what consultation took place with the current membership of the Defence Honours and Awards Appeals Tribunal during the drafting process?
Thank you, Senator. Yes, so early discussions began with the Tribunal back in 2021, 2022, which was not specifically on this draft bill, but more on what would we like to potentially see in draft legislation, what are some of the shared challenges that we experience, and then fast forward a little bit in 2024, the first concepts of this draft bill were shared around April 2024 with Tribunal.
Who was that shared with?
The Secretariat at the Tribunal.
We have heard evidence today that there was no consultation with anybody. So are you refuting that?
The consultation was certainly with the Tribunal, certainly in those early days, and then heavily as the bill was drafted. There were many additions to that, and some of the bill changed along the way, which was as a result of that helpful engagement. And then, of course, the Minister spoke at the ESORT, as you've heard, and then I think it's important that we acknowledge how valuable this inquiry is to hear from the people that have spoken today, but also all the other submissions that have come forward. So that's been very helpful too.
I do believe that the Department of Veteran Affairs considered that the Minister's comments at ESORT were so inconsequential that they were not recorded in the official meeting minutes. Do you have a view on that?
No, sorry, Senator, no, it's a matter for ESORT, but thank you.
So was it part of the agenda for the meeting to discuss the bill?
I'm unsure and unable to answer that question.
Okay, and how about consultations with the rest of the ex-service community?
Certainly there was no further consultation with the ex-service community as has been described today.
And why wasn't there any consultation?
I believe the decisions were ones taken where consultation with the Tribunal was valuable and with government.
So it was not valuable to have consultations with the organisations representing veterans? It would have been valuable, and I'm certainly valuable today hearing the insights that people have brought forward, but I don't have a comment as to why it wasn't valuable or done in that point in time. Okay, and given such significant rejection of this bill, I think we noted that 61 out of 62 or 62 out of 63 submissions had negative perceptions of this bill. In fact, many people have outright rejected it, or many organisations have outright rejected this bill. Do you think it's probably worth taking the bill off the floor of Parliament and going out to consult with everybody on this?
Thanks, Senator. I think there's still valuable reasons why the amendments to this bill proceed. Certainly, it's open to this committee to suggest some amendments, which certainly what we've heard today and read in the submissions speaks to some of those concerns, particularly around the time periods and alike. But I do think the reason for wanting to put forward some amendments to this bill is that there is a problem to solve here. One of that speaks to the issues around evidence. And that is, as we've said, going back in time becomes more challenging. Now, that isn't specifically speaking to finding a service record. It's speaking to having access to decision makers of the day who were part of how that operation took place, the decisions that were taken in the moment. When they are not available and they didn't necessarily record their decisions, their thinking, that makes it really challenging for the department when we try to look back and undertake the merits reviews of these historical cases. The second one would be putting the family and the member at the centre of the process, as you've heard from the Rear Admiral, that it is written in a way such that consent is not required at the moment, and we truly believe that's very important to insert. We do want to stop self-nominations of honours. It's not in the integrity of the Defence Honours and Awards system, and it goes against the position that we take, and that would be another reason that we would like the amendments to proceed. And there's a few other ones if you'd like me to continue, but I'll pause for a moment in case you've got further questions.
Thank you. No, I just would like to perhaps reflect and seek your view on this, that we have heard a lot of evidence today that there is no problem to be solved here. And so a lot of people are just sort of scratching their heads as to why this bill is going ahead. It is a resounding question that has been asked by everybody on this panel, and a lot of the evidence given today, and in fact I believe by the Tribunal as well, is that there is no problem to solve here, and they are doing a terrific job in the review process with the Tribunal as well. I just wondered, your submission says that the Tribunal places a significant administrative burden on the Defence Honours and Awards team. How many permanent full-time staff are currently employed in that team?
I'll need to take that on notice. Do you mean in the team responsible for the specifically looking at the historical honours requests, or all awards that were processed through this honours and awards team?
If we can get that all broken down, that would be terrific.
We can.
Thank you. And also how that compares to staffing levels over the past 10 years, or for as many years as the records would permit, that would be terrific. Thank you. The Tribunal has stated that the proposed changes would render invalid 95% of applications decided by the Defence Honours and Awards Tribunal between 2020 and 2023. Therefore, assuming their work would effectively dry up. So when proposing this legislation to the Minister, was there an associated cost saving from reductions in the Tribunal sitting fees?
Thank you, Senator. No, cost and resourcing was not a consideration in the bill proceeding to the Minister.
Okay. Has there been a consideration of, I mean, is part of the reason why you're doing this your concerns about the workload for the Tribunal?
No, we're not at all concerned about the workload for the Tribunal. Okay.
I note in its submission to the 2024 Honours and Awards Senate inquiry, the Tribunal expresses a view that it has, quote, experienced little, if any, difficulty in obtaining relevant and reliable evidence to allow it to make sound decisions in relation to Vietnam and all subsequent conflicts, end quote. Does Defence have any specific examples of a lack of reliable evidence when the Tribunal has considered appeals from actions relating to the Vietnam War?
Senator, I might start with the response to that question. I think it comes down to the breakdown of the different levels of awards and conspicuous service type decorations that are awarded. So when we look at long service awards and campaign awards, the records are quite simple. And and I'm not saying the records have always been perfect and they continue to improve, but if an individual was to query their eligibility for a former campaign medal or a long service award, that's actually a relatively simple process for us to interrogate our systems and give a quite simple answer on that. Where we come into complexity, which I think is where your question is going, is when we get into the honours awards and people having a view that maybe they should have received an honour, maybe a friend or a colleague should have received an honour. And as time goes on, it becomes more difficult to get evidence of the contemporary decision-making system at the time of that award. So, there will be lived witnesses. There may be witnesses who have passed away. There could be records in various states in the archives in Defence. And we certainly have a very rigorous process for digging in and finding those records right across the Australian Government archives. But there is no doubt that as time goes on and people pass on, unfortunately, it becomes very difficult to be able to compare an action of the time against another like or near like contemporary action of the time because of the passing of time.
Okay. I think where my question was going to is that we heard evidence from Ms. Cole just before that the problem to solve is that it is issues around evidence, but we have heard from the Tribunal, and it's said in this quote previously as well, that they've experienced little, if any, difficulty in obtaining relevant and reliable evidence to allow it to make sound decisions in relation to Vietnam and all subsequent conflicts. So I'm just still trying to understand, is this really a problem that we are trying to solve here when the Tribunal that is set up to, address those particular issues is saying everything's okay here?
Yeah, thank you, Senator. I'll try and explain a little bit further. It is complex. So when the Tribunal, and I don't speak for the Tribunal, it's just what I've heard them say here today, that they are looking at a merits review of the individual case, and they don't need to, as part of that review mechanism, look at any other information that might have been in play. If we take it back a step, when defence does a merits review, it's a very initial request, so someone comes and asks for historical honours. If we just use the example of Vietnam, the actions taken will be to search for all available evidence that we have. Certainly since 2023, we've started to do full merits reviews, which would involve contacting the applicant, trying to find witnesses, going to the National Archives, going to the Library of Australia, etc., to try and looking at service records, obviously. And often what you can see there is action may have occurred, the battle certainly occurred, etc. But what might be missing is what did the commanding officer or others necessarily see, and then what else was going on play around them in that particular campaign that they were subject to. So, for example, quotas were a requirement in the Vietnam War, but they're not now. We don't have operational quotas against honours, but they were in play there. So some decisions proceeded with some justifications, but perhaps not recorded is why were others not proceeded? And there might have been justifications for that, but we can't find it. That's one of the challenges we have. But of course, when that is appealed, the tribunal doesn't need to look at necessarily all of that information that we struggled to find. They can just look at the action and hear the testimony, and that's obviously the lived experience, and that's very important. We just try and get the totality, and that's where we struggle.
Okay. This is a final thing from me, Chair, very quickly. I just wanted to give two very vivid examples of the lived experience, if you will. First case is the young Victorian policeman who died out serving in the police force. He also served in the Reserve Army. He died in the year 2000. And it was only this year that his family became aware that he was actually eligible for a medal from the Defence Force as well. Now, we're talking 25 years there. And, with this arbitrary 20-year cut-off, his family would not be getting the recognition that their son deserved. And the other example that I would give is that I've heard of, people applying for their long service leave, and the records in defence are actually do not match the records that these people have. So, they're being denied their recognition for the long service leave as well. So, I feel like this bill just needs, it's missing the mark on all of this. If we're going to think about these are real people, with real lives, I just feel like it needs that consultation process.
Senator, I might start on that response. And you started with Norton, and also Shem would be another recent example. And two Australian heroes, military heroes that are celebrated, both, I agree, had a very difficult process to go through before they were awarded the Victorian Cross because of the length of time that had passed, the difficulty in finding records. Once those determinations were made and those awards were given to families, that's celebrated by Defence. And, I think it shouldn't be an easy process to retrospectively award recognition at that level. There is nothing in this proposed amendment to the Act that removes the power of the Minister to direct the tribunal to make an inquiry into a matter. So if there was a public interest or a political interest or an ex-service organisation that got behind a movement to recognise an individual because of information that comes to light with release of cabinet records or other records after 20 years that come open, and that new evidence warrants pushing this up through a process where such an award might be considered, the Minister could direct an inquiry into that.
All right. Thank you, Admiral. Thank you, Ms.
All right,
Cole.
thanks a lot. Okay, now, Senator Lambie, you've got the call.
Yes, thank you very much, Chair. Thank you for coming this afternoon. So the Royal Commission in Defence and Veteran Suicide did not recommend changes to the honours and awards systems. And the recent FADC Committee inquiry into honours and awards reported in June 2025 made 6 recommendations, which, by the way, you've addressed. None of them have been certainly addressed. They haven't touched, those recommendations haven't touched how this bill's been implemented and where those things actually come from. You know, it's so. Can you explain what specific problem the bill is intended to address? Because none of these have been addressed in the Royal Commission. None of these have been addressed, in a few months ago. So instead of actually prioritising on what you should be doing and worrying about what is going on with the health and mental well-being of those veterans serving, that is really concerning. And I think we're all just flabbergasted, just wondering as diggers why you would be bothered doing this when, you know, it's such a distraction. It's like, why aren't you doing the real things that are going to matter and save our mates? So maybe you can explain that to us, because we're wondering why you're spending time on this when there's many other things that were recommended from that Royal Commission especially that you probably should be spending time on.
Thank you, Senator. You would be aware of the 54 recommendations from the Royal Commission Defence and Veteran Suicide that specifically have the lead by defence. Another 23 recommendations that we share with DVA. There is an enormous body of work going on this year to commence the implementation of all of those recommendations, and our priorities at the moment are the health and safety of our people and dealing with some of the sexual misconduct issues in the ADF. And perhaps we can talk longer in a different forum about the immense work that's going on in that area. If I could address your question about the previous inquiry into Defence Honours and Awards, one of the issues that did come up in that was integrity and fairness of the process. And there were many questions on that. There's a great deal of discussion on that. And I think what the amendments to this Act help us to do is maintain the integrity of the system by putting some boundaries in time. There's no doubt there are changes to the appeal timeframes, and I'm sure that will come up in near discussion. But what it does is it also protects those that have received awards in the past and make sure that those that are considered for like awards are measured in a way where the evidence is contemporary, it's valid, it's accurate, and it justifies those awards. And so in broad terms, I would say it addresses the integrity and the fairness aspects.
So I just want to go back on the CODIS review, what was recommended, which was trauma-informed administrative procedures, which, unless I'm looking at this, it's not in this bill. Do you see that in this bill? So,
Senator, I would include the adoption of inviting families into the process and ensuring that individuals who might be impacted by a future award have had the opportunity to be a part of that process, or their surviving families have had an opportunity to be a part of that process as being part of a trauma-informed approach. Obviously, receiving particularly some of the higher levels of recognition that we're talking about here will have impacts on people and families. And under the current awards system, before someone is offered an award by the Governor-General, they're contacted to ask if they would accept the award. They're given the option, and that's part of the trauma-informed approach. Some people will decline an award. We need to make sure that families have that ability as well.
Okay, and can you tell me do you know how many cases have there been of a member obtaining defence awards fraudulently? And of those fraudulent cases, how many were then subject to a review by the tribunal? And has a member been charged with fraud in relation to honours and awards?
Senator, I'm not aware of any awards being obtained fraudulently, but I'll pass to my colleague to see if she has any knowledge.
No, I'm not aware of any either, Senator.
Okay, not a problem then. I have no further questions. Thank you so much.
All right, thanks, Senator Lambie. Now, Senator Pocock, are you there?
Thank you, Chair.
No
thank you both for your time this afternoon. Ms. Scott, I just wanted to challenge you on what you said about consultation around this bill. We heard the Chair of the Tribunal say this morning that the Tribunal wasn't consulted in the development of this bill, and he contends that where there was consultation, this was only after the core components of the bill were agreed between the Minister and the Prime Minister. And I'm interested if you would agree with this characterisation, whether or not consultation maybe did happen, but it was actually after there was agreement on what the bill would contain.
Thank you, Senator. The Tribunal is correct in that the consultation on the specifics of the bill occurred after policy approval, but the consultation and engagement, if you like, on types of things, so things like time periods, cancellations, periods to who could apply and so on, they were all in pre-discussions, but possibly not under the umbrella of consultation on a specific bill. It was just workshop consultation on changes that might be required in the future.
And Ms. Cole, were you involved with this bill from the start?
I was, Senator, yes.
Why was the decision made not to consult early on?
The decision around consulting the Tribunal was the decision taken in the early stages, and that's the decision that we
Sure. No, I understand you took that decision. I'm asking why. Like it just strikes me as such a waste of time for the Senate to spend a day looking into this where clearly there's no support for the bill. There hasn't been consultation on the bill, and people are visibly angry and upset that after the Royal Commission, this is the priority of the government in this Parliament in terms of legislation. So why did the department decide not to consult? There must have been a reason.
Thank you, Senator. No, the decision was to go to ESOT in August of last year. So that was the decision taken, and I just acknowledge the views and testimony by those here, and we can only be grateful now that we've heard those views that consultation is important. So we acknowledge that.
It certainly is. Thank you for acknowledging that. Rear Admiral, you said that issues of non-family members applying for honours is a concern. Outside of the one that you outlined where it was on behalf of for a group, how many times has this occurred and how many complaints have been lodged regarding this?
Senator, I couldn't give you a number for how many have occurred. I can give you some context, though, that we do have people all around the world that look at military history studies. You might pick up elements of a battle, an action, and decide that they have an academic interest in it, for example, and then may choose to nominate an individual for some sort of honour or award. It's very difficult under those circumstances where they're at a distance looking at some of these historic events to be able to gather the context around what happened at the time on the day. What was the weather like? What did those around them do? Was their action any more historic than those that were 3 metres away from them? So, there are some occasions where families haven't been engaged. Likewise, and there's many occasions where families have been engaged by those that are doing the research and have committed the research as well.
Sure. Thank you. Maybe on notice if you can tell us how many complaints have been received about non-family members making submissions, and then also to your other point, how many cases of international scholars or others have there been of I guess making recommendations. I
might pass to Ms. Cole, Senator. She has some data on other affected people.
This might help you, Senator. Since the establishment of the Tribunal for honours, we can see that we have 14 other people. The breakdown of the other category, be it a historian or an interested party, I don't know that level of detail, but just that they were not the member affected, they weren't the family, they weren't the witness or a chain of command. But I also have the breakdown of those people.
And of those 14, maybe how many the family sort of took exception to that?
I understand your question. We don't have that level of detail today. We'll get it for you on notice.
Rear Admiral and Ms. Cole, I just wanted to draw your attention to something that Mr. Skeel said in his opening statement this morning. Defence's submission says to quote, ensuring that affected persons are at the core of applications for defence honours and awards reviews is imperative for the well-being of members and veterans. Mr. Skill then went on to say, and I'll quote, in what parallel universe can defence even contemplate claiming that the well-being of its people is enhanced by stripping them of their present rights to challenge defence decisions that they believe wrongly deny them a defence honour or award? The bill works against the well-being of defence personnel, notwithstanding that defence says this is imperative. I wanted to give you an opportunity to respond to this comment, particularly against the backdrop of the Royal Commission and the need to implement recommendations. Will this bill improve the well-being of defence personnel and veterans?
Senator, thank you for the question. I might commence the defence response on that one. The amendments to the Act are not designed to do harm. They're designed to improve the integrity of the system, and I'm a firm believer that every process should continually evolve and improve with time as we learn lessons, and that's what this is trying to do. If I could perhaps give an example of the Tribunal's 2017 report into those Far East prisoners of war. We know that there were 22,000 prisoners of war in that theatre. 8,000 died in captivity. 300 cases were very carefully investigated by the Tribunal, but as a result of lack of evidence, only 15 names were recommended for some level of recognition. Now, none of this is perfect science. There will be many acts that they didn't look at which would have been brave, heroic, that we'll never know about. Probably every conflict we've been in, there's been acts that have been taken by individuals that haven't been witnessed that would have been worthy for these awards. So it's not an exact science, but I think we have an obligation and a right to do our best to try and protect the integrity of the awards that have been given at the time of those battles and those events occurring, and put some boundaries around what the effects of time will have on being able to obtain contemporaneous records and decision-making processes of that. So we came up with an initial view of that 20 years would probably be an appropriate time frame. We put 6 months around the appeals, recognising that other tribunals had 28 days generally, but we thought 6 months is more appropriate. And we've heard the feedback this morning and today that the 20 years has been questioned, and I think we need to have a discussion about the 20 years. But you know, the Tribunal, and I acknowledge that the chair of the Tribunal's views have changed to the previous Tribunal, but there is no doubt that as time moves forward, it is more difficult to get those records, contemporaneous records.
But Rear Admiral, you raised just earlier the case of Teddy Sheehan, who you rightly described as a hero. And we know that if this bill had been in operation at the time, Mr. Sheehan likely would not have received the Victoria Cross. Great to hear that once it was decided, the decision to award Mr. Sheehan was embraced by Defence. But why are you cutting off that pathway to an outcome which seems right and has been celebrated, which is clearly in the public interest, and I think honours bravery like that? Why are you cutting that off?
So, Senator, my response to that would be that the mechanism still remains for the Minister to direct an inquiry into any matter that he wants the Tribunal to look at. So, you know, when we put in place an arbitrary 20-year review period, 25 years, you know, a quarter of a century is a long time if we were to extend. You know, I think what it does is helps protect the integrity of those previous awards, but we're not closing the door to new evidence of heroic cases that comes forward through whatever means, and the Minister retains the right to direct an inquiry through the Tribunal.
Rear Admiral, one of the things that has come up today is that Mr. Skill was saying that in around 30% of cases, when they challenge Defence, either changes its view on application or Defence's decision is set aside. He stressed that Defence makes thousands of decisions about honours and awards, and that the few applications that they do are often difficult, but really important cases. 30% strikes me as a pretty high rate to have something overturned or revised, and I'm interested if you think that there's need for reform within defence when it comes to how you're making these decisions, if on appeal 30% are being overturned.
So thank you for the question, Senator, and I'll commence the response. I think Ms Cole might have something to add on the end of this as well, but in terms of defence honours, which I think is where most of the questioning is at the moment, 4% of those defence honours are reviewed by the tribunal. 59% of that 4%, they determine in favour of defence's original decision. Only 14% of that 4% do they dissent with with defence's decision and make a different determination. So I think that the numbers actually reflect the integrity of the defence's system. We also, I think it's important to know, still have administrative review procedures, administrative law review procedures in existence in defence. So if an initial decision on a nomination is declined, there are administrative law review procedures available as well.
Thank you. And just finally, I guess in response to that, when I asked the chair what was going wrong with some of defence's decision making, he gave an example where defence had failed to view footage that had been submitted to defence in support of an application, and said when the tribunal actually viewed the footage, it was very clear that the award was due. I'm interested if you're aware of the case, and if so, has there been work done by defence to actually change their processes? That sounds like a fairly clear example.
I'm not specifically aware, Senator, of that case, so I prefer not to speculate. What I can hopefully assist you with is to expand on the Rear Admiral. Some of those statistics you mentioned where defence might overturn its original decision itself rather than the tribunal, often that is when new evidence is presented after someone has appealed. So that's most helpful because we can revisit the original decision and see that in that case the medal should be awarded. So we do that to save the whole appeals process. That occurs. I also wanted to add that when we look at merit reviews for historical honours cases, we ourselves recommended 30 in the last 5 years, I think it is, that that's gone through defence on its own and hasn't required the need for the tribunal to review it, because we have leaned in and looked at, when we look at the evidence, we could see enough information and we have awarded those awards. So I think it's important that we do that work, and we do look to, if we can at all get the evidence, we will go that way.
Well, thank you. That's really good to know. I guess just finally, I would really urge you to, in future, to obviously consult more, but maybe in the meantime to actually consult with the many people we've heard from today about how to consult and what that could and should look like in the future, because I have real concerns as a senator when you turn up to something like this to look at a bill that just has zero support, like not a skerrick of support amongst people that we've spoken to. I appreciate your time. Thank you, Chair.
All right, thank you very much. Now, Senator Whittaker, and then we'll have to wrap up for the day, unfortunately. But Senator Whittaker, you've had the call.
Thank you very much, Chair. I just have a couple of questions and we'll try and get through them quickly. So just a point of, I guess, clarification. Does the tribunal play any role in conferring honours or awards?
Thank you, Senator, for the question. No, they don't. That responsibility is one that has always been with the department and will remain with the department. What we're talking about in the sense of this bill and these amendments to the bill is in a case where, in most cases, we award and we tell people why, but in the case where we perhaps cannot recommend them for an award or issue an award, they will get a letter that outlines the reasons why in accordance with administrative law, and they afforded the opportunity to go to the tribunal to seek a review of that decision.
Thank you. And just, you went to this, I think, a little bit in your response to Senator Pocock's questions, but it sounds like Defence does carry out some internal reviews of the merits of a case in where there have been refusals. It doesn't necessarily, that responsibility doesn't solely lie with the tribunal.
Absolutely not. No, they're reviewing our original merits review decision. So as I think I mentioned earlier, from 2023, we started to do full merits reviews. But prior to that, it was more, was there new evidence or maladministration evident? So that shift was another, I guess, advance for Defence. But if you like, I can talk you through that when a request comes in, and it might simply just be a veteran or a family member asking if they could receive a particular honour for a particular action in a particular war or campaign, we would then go about trying to source all the relevant information, including anything they've provided. That includes all those avenues I think I mentioned earlier, very thorough. And then a report is compiled to a decision maker, and that decision maker looks at the actions against the specific eligibility criteria and does it meet that eligibility criteria? And then if it's a recommendation, it'll proceed through the normal process that current serving members proceed through, which is a recommendation to the Chief of Defence Force, a recommendation to the Minister of Defence Personnel, who recommends it to the Governor-General, who approves it. And at that point, members are then sounded out through the Governor-General, would you like to receive this honour or not? Because honours are a gift, they're bestowed upon people for their actions and exceptional service.
I am conscious of time, but just very quickly, why did you, or the department, or perhaps it wasn't the department, but the 20-year time limit, what was the rationale behind that being chosen as the time frame?
Yeah, that's a great question. I'll start, and I'm sure Rear Admiral might want to add. Originally, we started to look at the what other Commonwealth countries do, which is a very short review period, if any review period at all. Certainly, we're the only country with an independent review mechanism like this. And because they were such a short period, I think the 20 years was very much from a point of view of being much more generous. But I think it's clear today, hearing the feedback and reading the submissions, that 20 years isn't considered long enough. And so the department is certainly open to whatever the committee might consider as a more appropriate period of time. Certainly noting that we've expressed those concerns we have around historical information, and it's not just the factual pieces of paper that go with the historical actions, it's the people and the ability to speak to anyone who's now deceased or simply too old. The other point I'd say is that in 1992, we stopped as a government issuing imperial awards. And so that's approximately 30 to 35 years ago. And that would frame the tribunal forward focusing on contemporary Australian honours and awards, medals and awards, rather than imperial, which at the moment, imperial action is being recognised with a contemporary award under the current Act.
Okay, that makes sense.
Senator. I agree with what Ms. Cole has said there. As we did a review of what other Commonwealth nations are doing, the closest that we could see were the UK and Canada and New Zealand. And there is a variance between all three of those countries, but some of them have a 5-year review period. Some of them have 2 years that you have to apply within. There's alignment with what we're trying to do here. With some of them don't accept self-nominations, for example. But none of them certainly have a tribunal like we do and we value. And certainly none of them have periods that extend out to 20 years. But we've certainly heard the other evidence this morning around that 20-year period.
Mm-hmm. And then my final question goes to the question of family members and the requirement that they are either a party to the request for review or consent to that review. Some of the evidence that we've heard today has spoken specifically to, for example, nieces or nephews or grandchildren who are excluded from the definition of immediate family members. I note that in bill, there's a difference in who is able to reply, the circumstances in which someone's able to reply for a review for a defence honour than for a defence award or a foreign award. And under the definition for a defence award or foreign award, there is a kind of reference to if the affected person is deceased, the applicant is the executor, administrator, trustee of the estate or other personal representative. I just wonder, is the intention of that other personal representative, is that like an official representative or could perhaps a niece or a nephew or a grandchild potentially fit that definition? And if not, then kind of why was the definition of immediate family member used?
Thank you, Senator. I might have to take the first part of your question on notice around that because it's a legal term and I want to make sure we're legally answering correctly.
Yeah, if you could take that on notice, that would be great.
First bit about why that extra person at the end, the reason the immediate family was taken on though was because it's from the Family Law Act, and it certainly that was the assistance of OPC helping us in the process. So yes,
so it's consistent with other legislation.
Consistent with other legislation, yes, and it does include grandchildren, parents, grandparents, siblings, and it includes step or adopted family members.
So grandchildren are included?
Yeah, the common law definition.
Okay, excellent. Thank you for that clarification. That's it from me, Chair.
All right, thank you.
And just in terms of the...
Sorry, we'll have to, unfortunately, due to time constraints, we have to wrap up. The committee would also appreciate if any responses that were taken on notice to be provided by next Tuesday at midday. Now, that concludes today's hearing, and I want to thank all witnesses who appeared and to Hansard and Broadcasting for their assistance. I did want to just say before we conclude, I did want to send our deepest condolences on behalf of the committee to the family, friends and comrades of the sadly Army soldier that passed away, as we've just heard this afternoon, from the 3 RAR, who tragically lost their life during the training incident near Townsville overnight. My thoughts, and I'm sure with all the members of the committee, thoughts and prayers are with all those people involved, including the other 2 members of the ADF who are currently in medical attention, and we obviously wish them all very well, the strength and a full recovery. But our heart goes out to everyone at the moment. And look, it's fair to say every day our ADF personnel put themselves in harm's way to protect and serve our nation with the highest distinction. And, you know, it is such a sad time to hear this news as we do hear some from time to time. But I guess on behalf of the committee, I wanted to pass on our thoughts and prayers right now with everyone that's grieving.
Thank you, Chair. Thank you, committee.
Thank you.
Thank you. All right. On that note, the committee now stands adjourned, and look forward to talking to senators at a future meeting of the committee. Thank you, everyone.